Welcome to Looking at Legal Stuff. Today we have 14 hearings in a minor guardianship filed by the maternal grandparents due to both of the child's parents being in active addiction and mom being currently in jail. Once the guardianship is established, mom immediately files to terminate it once she's released, and she's awarded supervised visitation until they have their trial. Once dad finally establishes his paternity, he too is awarded supervised visitation with the child. The problem is, the guardians keep refusing to allow visitation, despite the GAL asking the court to tell them that they have to. She says that the guardians keep saying that the parents are supposed to provide weekly clean UAs, but they aren't getting them properly, and that's why they've refused to let them see the child. Let's see what the judge will do about this.
Guardianship of Jessica Vorse.
Yeah, this is Mike Vorse. I'm here. This is Mike Vorse and my wife Carla as co-guardians.
And I understand the mother started a prison sentence yesterday. Is that right?
Yeah, I think actually Tuesday night.
Okay. So what I am missing at this point is proof of service on either of the parents of the petition. Where do we stand on that, sir?
They were served.
On Monday.
I guess I didn't know what I was supposed to do for proof. I did on Monday when we picked up the girl. There was an acquaintance of mine that did serve him.
All right. Well, I need an affidavit from that person saying, you know, on this date at this time, I served these papers on this person so that we know that they've got notice.
Okay, how do I do that now that she's in jail? Can I just take something there and have her?
Well, yeah, you can have her served at the jail or at the prison. But I've got to have proof that they've been served before we can do a whole lot.
Okay, I should be able to do that today then. I did serve her with a copy that I got, but I guess I didn't know anything about the affidavit.
Yeah, we've got to have proof that the service occurred. And you're going to need to proof service on the father as well.
Well, so I have an assumed father, but I don't really know for sure who that is.
And I think that's the best you're going to do in this circumstance, and it may have to be by publication. It's up to you how you pursue this at this point. But this is a very difficult statute. A lot of its provisions are pretty unworkable. And navigating this without the aid of an attorney is difficult, to say the least. So I would urge you to consider asking an attorney for some help, especially on the service issue. In the meantime, I'm willing to extend the guardianship, the emergency guardianship order through a January 4 date, and I'll fill that order out here. In the meantime, you've got to get proof of service to the court so that we can do anything by that date. Understood?
I understand. I'll do it.
Thank you, sir.
Guardianship of Jessica Vorse. This is 234-00-41708. I know I saw Michael Vorse. I saw Katrina Vorse, the mother petitioning. I do know we have an observer. Is anyone else here on this matter?
Yes, Your Honor. I'm Jack Carnahan. I am Jessica's father.
Okay. Thank you both for being here. So, I know I had a few of these parties on protection order docket yesterday, and we kind of all talked about letting this go first. So we are here. I have not, I don't believe, had this case in front of me yet. I think it's primarily been with a different judicial officer. I did go back and review the notes, and it looks to me like the petitioners, after filing their show cause matters, did have a date set for a decision on the order on the emergency minor guardianship. on January 4, 2024, which will be the first Thursday after the new year. So that's on the calendar. What I have in front of me now, though, appears to be, number one, Ms. Vorse, the court did receive your objection, but number two, you have noted on a petition to terminate the guardianship. So my understanding is that we are here, Ms. Katrina Vorse, on your motion to terminate the guardianship.
That's correct.
Okay. So I don't see that we have any, but correct me if I'm wrong. Has anyone been appointed a court visitor or a GAL in this matter?
Not that I'm aware of.
Okay. And then I had a question. I believe, let me double check my work here. Is Mr. Carnahan on the birth certificate?
Yes, he is.
Okay. Has he been served with this petition?
No. Well, he was with me when I did the petition, but he hasn't been served anything.
No, sorry, Ms. Vorse. I mean the underlying minor guardianship. So now I'm talking to Michael Vorse, the guardians, the proposed guardians on the underlying petition. I saw that you originally had listed Mr. Carnahan as the father, but then you crossed it out and wrote unknown.
Yeah, that was, because it is unknown, we got conflicting reports even in, from what Jack Carnahan told the doctor and to what, they both told the sheriff's office, and then another statement by another person where they're moving in now that his son was the father. So, we don't know. Jack told me that he was gonna get his name put on the birth certificate. So I don't know when that happened, but he just told me that probably a month ago.
So is there a birth certificate with Mr. Carnahan listed as the father?
Yes, there is. I just don't have a copy of it yet.
Okay. We are going to need that because that is going to dictate whether the court can move forward on the underlying guardianship.
Okay.
Um,
I have the piece of paper that states that the Olympia sent me saying that he has been put on it.
okay. Well, we'll need the actual birth certificate though.
Okay.
So let me ask you this, to the current immediate emergency guardians, are you objecting to of the guardianship?
Yeah, I'm objecting to it. Yeah, it's not best for justice.
Okay. So my thought here, Katrina, I am going to hear from you in just a minute, but on the underlying, gosh, there's so many potential issues with this case. You all are not going to be ready for a hearing on January 4th unless we get someone involved. So first of all, I do believe just on the underlying matter, we need to appoint a court visitor. That person can help with service issues, with birth certificate issues. They can also file a report with this court as to their recommendations regarding whether there is a parent able and willing to meet the needs of this child. So I am going to appoint a court visitor. The court will let you know who that person is. How old is Jessica?
2.
2? Okay.
Yes.
Okay. We'll assign a court visitor. Just going to fill that out quickly. That'll at least keep you all moving forward somewhat. The other thing, Ms. Vorse, at least at this point, until we know that Mr. Carnahan is a party to this action, I can't appoint him a lawyer, but I can ask you if you would like to be screened for a lawyer in this proceeding at no cost to you, depending on your current income.
Yes, please.
Okay. So tell me what your current income is.
I get just under $1,000 from Social Security and
Okay.
SSI.
Okay, and is that income or medical needs-based program?
I get SSI and SSDI.
You do, okay. So I am gonna find that because of those benefits, you do automatically qualify for a court-appointed lawyer. I will assign you one. And also you will get that person's name. So our judicial assistants take my order. They call around with the names of the parties involved. So we make sure we get an attorney appointed to you that doesn't have a conflict. And then they will reach out to you with that attorney's contact information.
Okay.
Okay. So because I'm going to appoint a court visitor and a lawyer, my recommendation or my first thought is to continue, not make a ruling on your motion to terminate today, but just continue this all to January 4, so that you can have an attorney present with you at that
Can I
time.
see her?
What?
Can I see her? They have denied me visitation for no reason whatsoever. They were not a part of her life until they took her from me.
Okay, so 2 things we can do. Number 1 is you can tell me, nope, I want to move forward without an attorney on my motion to terminate. And I can take testimony from you and make a decision on that motion. Or if you want to wait and have an attorney present on your motion to terminate, what I can do today is address visitation, but keep the temporary order in place until January 4th. I would say you will be best served having an attorney present during an evidentiary hearing. So I'm not going to make that decision for you, but I'm trying to tell you what I believe most people would do in this situation. But I'm happy to address visitation with you without waiting for a court-appointed lawyer.
I just want to see my daughter. I mean, I haven't seen her in almost 2 months.
Okay. So let's start down this process of visitation. So Mr. Vorse and Mrs. Vorse, well, everyone has the same last name. Let me say Carla and Michael. I mean, no disrespect by using your first names. I think it's just going to be better for the record. Right now, you have a temporary restraining order in place where Katrina would be unable to come to your home and is not to go to the daycare or school of the child. My understanding is this is a pretty recent placement, and up until that time, the child did have regular contact with mother. So are you objecting to some form of visitation at your home or some other location between Katrina and the child?
I think it'd be fine as long as it's like you had a court-appointed supervisor, just really.
Well, we don't do that. We don't have parental supervisors.
Some kind of third party.
Do you not want it at your home?
I'm not
No,
allowed there.
because they showed up and wouldn't leave. They haven't trespass off the property.
Okay.
Made threats to me, as you might have seen in some of the things that I filed. He said he was gonna make me pay for this. So, and no, just because of their attitude towards it. Yes, we did have professional opinion that it would be best for Jessica, and I will tell you, she's doing very well. And I did send pictures to Katie of her getting the cards where she finally sent the cards, but
Do
we
you?
just like to have somebody else outside of the home.
Okay.
We can watch and monitor, and they don't come back and accuse us of anything that I just don't want it. They've made it so difficult.
Is there a third party that everyone trusts, like a family member, a cousin, an aunt and uncle, a grandparent, someone, a friend that you all trust that could be present for visitation? And this is just for 2 weeks until Katrina, you get a lawyer and you can actually argue your motion.
What about the CPS worker that's been working with her?
My CPS case is in the process of being closed.
But I mean, Naomi, is she available? And is that something that she would do?
I don't know because she said she was closing out my case.
Yeah, I can't mandate a government worker to do that type of work. Now, parents can pay for a third-party supervisor, but that does cost money, and it does not sound like that's something that Katrina is going to be able to afford. So that's why I'm asking, is there a person that doesn't need to be paid? It's not their job. They're doing this to help you all over the next 2 weeks that would be there during visitation.
Your Honor.
I hate to put any, just honestly, I hate to put anybody in jeopardy, like even other family members. Katie's made some very ugly remarks about
Well,
family.
Katrina, you're the one asking for visitation. So
Naomi,
who are
Or
you,
I'm-
who are you proposing?
or
Naomi,
I'm- Who
sorry.
are you talking about?
Michael, hold on. Michael, stop. Michael, Katrina, please go ahead.
Well, I'm currently staying at Jessica's grandmother's house. It's not her biological grandmother, but it is her grandma
Since birth.
since birth.
I
And
don't know
I'm
what that means. It's not her. Who is this person?
Sandra Galster.
Right, but you're saying it's not an actual grandma, but it's a grandma. How is she related to Jessica?
She's not related. She's a step-in grandma, meaning that she's taken on the role of grandma.
Okay,
Since birth.
But I'm currently residing there, and she said that we can use her home and that she'll go and get Jessica. And there's no criminal history with her.
well, I don't know that. So I'm see Michael and I'm apologizing. I'm gonna blank. Remind me your first name, ma'am.
Carla.
Carla. I almost said Carly. Carla. I see you shaking your head. Do you know this individual?
I know of her, but Naomi, the caseworker, just texted.
I can't hear a word you're saying. You're cutting out.
She said that Naomi, the caseworker, said that she would, if need be, I'll pay the cost for her to be in. She is a professional that knows what to look for, and I would rather not put any of my family in. Sandra, she sounds like a nice lady. I've talked to her a couple of times, but I'm not ready to go there from what.
Okay. Let me just confirm. So you said, so Michael and Carla, you have received a message that Naomi would be available to take this role on for the next 2 weeks.
Yeah,
Yes, it doesn't sound.
Okay. So that would, Katrina, what's your thought about that?
I just know that Naomi's busy, and I haven't heard anything from Naomi. Last I heard is that she was closing out my case.
Okay, so
She just.
Well, I don't have that text message, so I can't confirm that.
I'm not asking you to confirm it. I'm asking if you agree to that.
Yeah, I guess.
Okay. So here's what I'm gonna do also then, because I do, Katrina, want you to have a lawyer present. I want Mr. Carnahan time to file. You're going to want to file the birth certificate with Mr. Carnahan's name on it well before the January 4th hearing.
We'll have it in by the end of the week.
Okay.
Mm-hmm.
I'm just gonna extend the immediate order. Nope, it's already extended, so it's actually already goes through 1/4. So the only new thing I am gonna do is issue. And I'm gonna do a new order that adds. Oops, where did his order go? Supervised visitation
I don't know.
between mother and minor. So Ms. Katrina Vorse, you'll need to reach out to Naomi to arrange times that work for the two of you for that supervised visitation.
She's texting me right now.
Yeah.
Okay.
Yes.
Can I ask something else to be added to the order?
Just a second. Let me finish where I'm at.
Okay.
So then the stay away provision is going to be modified just to the guardian's home, workplace, or school. I'm not including the minor in this at all because we are allowing supervised visitation. So I am going to make that change. And then Jessica is 2 years old.
Yes.
Okay, Michael Vorse, what did you want to talk about?
I wanted to add Jack's name to the restriction order, to the,
He's not a party yet to this case, so I'm going to decline that.
okay,
I don't have jurisdiction over non-party because your petition indicated the father was unknown. So I need to have Mr. Carnahan file proof that he's on the birth certificate, and then he will need to be served with the original petition if he hasn't already been served.
Oh, he hasn't.
so how will I know when that happens?
I'll file a response.
We'll file a response.
It will be filed in the court record.
So I mean, when that birth certificate is filed, then how will I know that it's filed and then to be able to have him served?
Well, you can call the clerk's office and find out what has been served in the file. Also, I would recommend that Mr. Carnahan serve that birth certificate on you if he's asking to be a party to this case. He also can file an objection. He can note that he hasn't been served. I mean, essentially, sir, it's incumbent upon you when you file these petitions to determine who the legal parents are that need to be served. So you're going to have to do a little work.
Well, the day we picked Jessica up, Katie told the cops that Jack was not the dad.
So how do we know?
I mean,
Just
you're
because they
doing a paternity test?
Just because they changed.
All right, folks, stop.
Okay.
They have been asked to file a birth certificate. You have filed a petition stating the father is unknown. Both of you have some work to do, obviously, because you're each telling me different things. Both things can't be true. So you all will have to bring that forward to me. That's not for the court to figure out. That's for you all to figure out. You're asking me for a decision. Bring me the information. I'm not going to tell people how to file information. I can't give legal advice. When you file these actions, you have to do your research as to what the court needs to give you what you're asking for.
That's the
So
whole point.
I have filled out a new temporary order through January 4, 2024. With the new visitation, I am going to appoint a GAL. We are going to get also, I'll have to get that order after docket. We're going to get an attorney at Ms. Vorse's request.
And Your Honor,
Yes, ma'am.
I was just gonna let you, that we will have that birth certificate ready to file tomorrow. So,
Perfect. Go ahead and serve that on Michael and Carla so they know that that you have filed it and that they can then make sure that their petition is served on Mr. Carnahan.
okay,
Because otherwise you're all going to come back here on January 4th and the judicial officer is going to say we can't do anything because the father hasn't been served.
okay.
All right. Thank you all. We'll see you back on January 4th.
Jessica Vorse. Who do we have present?
Your Honor, Hannah Cowden, attorney for guardians Michael and Carla Vorse.
Donald Esau, attorney for Katrina Vorse, the mother.
And Jack
Tina Day,
Carnahan,
court visitor.
Jack Carnahan, Jessica's father.
And Katrina Vorse, her mother.
Okay.
And my client is also here as well.
Okay, thank you. All right, so at this point, trying to figure out what in particular is going on here. So if you can kind of let me in of what the plan is or what's going on.
Your Honor, we are requesting a continuance today, and I apologize. I did not unmute myself fast enough at the beginning of docket. My notice of appearance was filed on the 28th, and given the holiday and our office closure, I need a chance to get up to speed. Additionally, it's my understanding that the court visitor, Tina Day, has an appointment to meet with my client next Wednesday, and to give her a chance to work through things, we're requesting a continuance.
How much of a continuance are you asking for?
At least until the 18th. If the court thinks longer is appropriate, that's fine with us.
Okay. Any objections, counsel?
I don't believe so, Your Honor, but we do need to address visitation. This case started back in November of 2023, of course, and my client has only seen the child once in that entire time. And the last order that was entered on December 19th provided for visitation in the form of supervised visits between mother and minor to be supervised by Naomi, pardon me, I don't know the last name, but it appears to be Frying or something with CPS. So I was just appointed on the 19th, and I received the appointment on December 26th. So it's probably a good idea that we both get up to speed before we proceed with further matters. But I think we can take up the issue of visitation today if Your Honor is so inclined.
Ms. Day, have you had any opportunity to look into this or have any, I guess, meaning any input at this point as to visitation?
Your Honor, I have not. I've just recently had contact with Mother, and she sent in her information, and we're in the process of scheduling a time for me to meet with her, which I'll coordinate with Mr. Esau. I do have an appointment with the petitioners next week, so I think it's appropriate to grant the continuance. I think in reading the petition, I think there are concerns about visitation at the parent's home, so maybe coming up with another location where that could happen, at least during this continuance time until I have an opportunity to see if there are concerns or not.
Your Honor, if I may also note for the record, the one visitation that has happened so far was upsetting to the child, and my client at this point would like a chance to have the appointment that is currently scheduled with the Progress Center before further visitation occurs. They've indicated that there are tools available to help the child work through the upset that has been occurring.
Yes.
Let me hear from Dad.
Your Honor, it's been 2 months since I've been able to see my daughter. I've been pretty much her primary caregiver. I've had her like 80% of the time. This whole thing, I believe, is just nothing but a power play on Mr. Vorse's part to get Katrina to bend in to his will of going to treatment. I myself have gone back into my 12-step programs, working with that. I have found a place for my daughter to come to that's drug-free, that's violent-free, that has children already. Excuse me, I'm really emotional about this, but I don't know what to do. I really don't know what to do. All I know is I miss my daughter, and I know she misses me.
So here's what I'm going to do at this point. I think there are a couple of issues. I understand counsel is new to this case and needs time, and I think the overall part of this needs to be, the broad picture needs to be addressed, but I also think visitation needs to be addressed, but I don't feel comfortable doing it today because I don't have any real factual background beyond what's been said to, and I don't want to assume things one way or the other. And so I want to give Ms. Day an opportunity to look at, to get some investigation time in and at least be able to put some information before the court to try to at least do some recommendations for some temporary time. And let me, hold on just a minute. Let me get to my file here. I thought I had it up. So it sounds like maybe DCYF is involved. Is that what I'm hearing, for the supervisor to be DCYF?
Last time when I had my visitation, she was supervising, but she said she could only supervise that one time because she was closing out Jessica's case.
Okay, all right. Okay. Well, especially with a young child, that gets concerning. Not that part. Just what I'm going to do is I'm going to set 2 dates. The first one I'm going to set is 2 weeks out. And I know that's more time not seeing the child, but I'm not going to order visitation at this time because I just don't have all the details that I need. Well, I guess the 18th. So I am going to set it over to the 18th. I'm not going to order any visitation at this time. And give Miss Day an opportunity to do what she needs to do so that we can have some reasonable terms put into place as to what that visitation is going to look like. So I'll set it to January 18th at 10:30 a.m. to look at visitation, as well as the broad determination of what we need to do to move this forward. Okay. Meanwhile, the emergency guardianship will remain in place.
Thank you, Your Honor.
Okay. Will you do some orders, counsel, to reflect that?
I'd be happy to do so.
Okay. All right. All right. That takes care of today's matter. Again, make sure to be in contact with Ms. Day so she can do her job. And then we'll look to the 18th to get things put together. Okay.
Okay.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
All right. So we're done with.
Thank you, Your Honor.
Thank you, Your Honor.
Number 6 on the docket, 234417-08, guardianship of Jessica Vorse.
Your Honor, Hannah Cowden, attorney for petitioners and minor guardians, emergency minor guardians.
Morning, Your Honor. Donald Esau on behalf of Katrina Vorse, the mother of the children.
Jack Carnahan, Jessica's father.
And Katrina Vorse, her mother.
Okay, thank you.
Mike and Carla Gore, the guardians.
Okay. So at this time, I just received about 5 minutes before walking onto the into the court a large stack of documents. I don't even know who they're from. And I have not had any opportunity to review those documents at all. So I'm not even sure who submitted them.
Your Honor, that's that would be us. That's a full petition for guardianship. Today, we would ask the court to be extending the emergency temporary guardianship. We would like the court to hear from Tina Day, as she was able to meet with my clients this week. And then I would defer to the court whether or not you want to discuss the full petition today or set that for a hearing at a different time.
So, Ms. Day, have you had a chance to do everything, or where are you at with things?
So I have not had a chance to do everything, but I have met with the petitioners, met the child, met with both of the mother and the alleged presumed, whichever legal term is correct for the father. I've talked with the social worker and mother's DOC officer, so I have some information to offer, but I would need additional time to finish this investigation completely.
All right, so I don't think it's appropriate to, I don't want Ms. Day to have to report when she doesn't have what she needs done. So I don't think that'd be appropriate for today. And then, so at this point, I would look at the extension of the emergency guardian order. Mr. Esau, am I saying that correctly? I'm never quite sure.
You are, Your Honor. Thank you.
Okay.
Yeah, my client's concerned about visitation right now because she's only seen the child who's 2 years old one time in the last 3 months, is my understanding. And I think one of the purposes of the hearing today was to hear from Ms. Day about whether or not more visitation is warranted. On my client's side of the ledger, she has a December 18th or 8th, 2023 drug and alcohol assessment, says she's fine. There's no symptoms. There's nothing going on at this particular point in time. The child apparently was placed initially with the guardians before they were guardians because she was going to be serving some jail time. And then after she came out of jail, then she was faced with this emergency petition for guardianship. So I don't believe we have any formal visitation in place yet, but my client believes it's appropriate for her to have the opportunity to meet with the child at least a couple times a week. This is obviously, this is a very young child. She's bonded with her mother. She's with people that are concerned citizens for sure, but I don't think they know the child very well. And I don't know if there's been any bonding since the child went to stay with them at this particular point in time. So we would ask for visitation a couple times a week, maybe Wednesday evening and a Sunday afternoon, something of that nature. Not supervised because no risk to the child here. It may be appropriate if the court is still concerned about the drug and alcohol issue, that there may be some sort of UA prior to meeting with the child, or at least one a week, or if that's appropriate, if the court thinks that's appropriate. My client doesn't think it.
After that happened after the last visit, and upon seeing pictures of herself with her mother, there is a appointment with the Progress Center for the child, I believe next week. And we would like the opportunity for the child to be seen by the counselors there before visitation occurs. We are also requesting in our residential schedule as part of the full petition that visitation be a subject that's revisited once the parents have shown that they've entered treatment for substance abuse after a full evaluation.
Ms. Day, do you have any thoughts at this point?
I do, Your Honor. So I've had a chance to talk with the social worker, the parents, and mother's DOC officer, and certainly substance use is a concern and is an active concern. I think mother needs to have a new evaluation as requested by her DOC officer because of a positive UA. Both parents admitted to infrequent but occasional use of substances that would give concern for this child's safety. I do think visits would be appropriate. I would recommend maybe one visit supervised a week. The library was a place that was used prior, and I think that's a great option and allows me an opportunity to observe the child with the parent, but it's safe. I do think a UA would be appropriate before visits to make sure that there was no risk of exposure of this child, because that's definitely one of the allegations that is involved in this petition for serious substances that could harm this child. So I think visits are appropriate, but I do think it needs to be limited, and I think the parents need to be able to verify that they would be appropriately clean at the visit. So a UA before would be appropriate. Supervised could be done by a third party. I think there's a couple of options. I know mom and dad were thinking of some individuals. I know the petitioners might have a name or two, so that it would be a neutral person, but it should not be anybody who currently lives or resides with the parents, because of the circumstances there and the concerns that have been raised, and I haven't had a chance to fully vet those individuals.
So, counsel, you said that the child was going to, I'm going blank on the name.
The Progress Center, Your Honor.
Progress Center. When is that scheduled?
I believe that's scheduled for the 25th. Mike, can you confirm? Yes, the 25th of January.
Okay. All right. All right. Well, Ms. Day, you're saying once a week. Is that what you're recommending?
I would recommend a once a week visit. I know that it's going to be difficult. This is a young child with a lot of emotional challenges and some pretty significant health challenges. So I think she needs to have contact, and it is going to be tough, but she's gone 3 months almost without seeing her mom. And I think that's a concern.
All right. Counsel, anything further?
Nothing further to add at this point. Thank you.
From us, Your Honor, we would like to do the Progress Center appointment before a visitation. We also need a little bit of time to figure out who would be a supervisor.
So at this point, I think it's important, especially with the young child, that parents have contact unless there is an issue. I understand the substance abuse being an issue. At the same time, if it's supervised, then I think that would be appropriate. So in regard to the mother, I do want the mother to UA. I don't know if a hair follicle test has been done, except if the admission's been made. I guess there's no point in that. But I would want a clean UA before having the visitation. So I will order, I don't want to wait till the end of the month and then wait another time. So I do want, and again, just expect that child's going to have issues, which I think it's good going to the Progress Center and addressing that. In regard to who that third party is, I'd prefer that the attorneys try to work out who that is. Rather than me naming somebody, because I'm going to get to one of the professional places that supervise, and that's going to be costly. So I'd rather see if there's a third party that the parties can agree on. It will not be somebody in the home of the mother or the alleged father. I'm not quite sure where that's at, but as to who that person would be, wouldn't be somebody in the home. So it needs to be at a neutral place where the visits occur, be it the library or some other place where there's some point of entertainment for a young child. I guess we don't have any of the fast food places with playgrounds anymore.
No, but we do have the location inside the mall that is
okay.
segregated for ages. So there's a place for younger children to be.
Okay, all right. That would be fine. Something like that is what I'm thinking of. Where am I? Please mute your connections. I'm hearing something. I'm not. Oh, thank you. Okay, so that's what I'm going to order once a week. I just want it for an hour. I know that doesn't sound like a lot, but I want to reestablish the visitation and just have a short time. It is a young child, so an hour for a young child seems like a long time for that child. So an hour once a week by an agreed third party at a point where the child has something to entertain and do. That place in the mall sounds like a good option, but I'll leave it to council to figure out who that supervisor is going to be. If not, then it'll be brought back on and I'll decide. Meanwhile, I'll go ahead and extend the emergency guardianship appointment for 30 days and allow Ms. Day to get her investigation done. that will be helpful with having the child go to the appointment at the end of the month. I think that would provide some information for Ms. Day as well. And then the mother should go ahead and get a substance abuse evaluation with input. I don't know if the DOC officer is the appropriate person or Ms. Day, but I'd like a third-party input in regard to the substance abuse.
Your Honor, may we request with the extension of the order that the restraining order currently in place for Katrina also include Jack Carnahan, as he has shown up at my client's property more than once, and we just would like to add him to the restraining order if that is okay with you.
Any objections, sir?
Yes, objection. There was one instance when this first all started that we had a problem. Since then, there hasn't been any problems with Mr. Bors or being around him or coming around him or trying to find him or doing anything. There was one incident when this thing first began. So I really don't see what the need there is. I'm still wanting to know why I was included and scratched off and then included in this whole ordeal.
I'm not sure, sir, and I'm not going to get into that right now. So when you talk to the guardian ad litem, Ms. Day, do you look into whether alleged or what's your part?
Yes.
Okay.
So my understanding is an acknowledgement has been completed by the parents, by Mr. Carnahan and mom, and has been filed. So we're waiting for that to kind of make its way through the process, but it is establishing him by acknowledgement. I don't know if that's going to be challenged in the future based on DNA or request for that. I don't know, but there is an acknowledgement in place, and that's working its way through the Department of Records.
Okay. So once that's done and you're established to be the father, just remind me the next court hearing that will address about getting an attorney for you. So we'll address it at the next hearing.
Your Honor, I'm already on the birth certificate. Didn't we file a copy?
Yeah,
we filed a copy of it in this case. It should be that I am acknowledged as the father of Jessica. So. And it's not about making it go through the record. It's already there. You should have it right in front of you.
We served it to Michael too.
And we served it to Michael.
So Ms. Day, have you seen that? You're muted.
Sorry, I have not seen that yet, but I believe it has been filed. I will review that. I just met with the parents and learned that this week. So I haven't had a chance to go back through Odyssey and see if that's been filed and or sealed.
All right. So, sir, there's a process. I know you may not agree with it, but there's a process we need to go through. We're going through it to make sure all the I's are dotted, T's are crossed. And just remind me at the next hearing and we'll go through the issue in regard to getting an attorney. Okay.
Can he see his daughter during the visitation?
So at this point, I've only addressed it for you until I get more information in regard to dad. I won't be doing that. We'll address those things at the next court hearing, but that will need to be his request and his conversation. Okay. So at this point, the visitation is just for mom.
Thank you, Your Honor. I appreciate it.
Okay. All right. That concludes the matter for today. Oh, 30 days. Let's get a date. We're on the 15th. So 1, 2, 3. So it'll be February 15 at 10:30.
Thank you, Your Honor.
And
All right. Thank you. Thank you, Your Honor.
Your Honor, may I clarify what your answer was to my question about adding Mr. Carnahan to the restraining order?
Oh, I apologize. I didn't answer. Let me answer that. Sounds like there have been issues. So for that reason, I will add him at this time.
Thank you, Your Honor. And would you like our office to prepare the order?
If you would, please.
Yes. And we'll get that over to you this afternoon.
Thank you. Jessica Bors.
Hannah Cowden, present, attorney for petitioners.
Lisa, present for the the mother, Katrina
Katrina Day,
Vorse.
court visitor, present.
And Jack Carnahan, father, present.
Katrina Vorse, mother, also present.
Mike and Carla Vorse, guardians.
All right. So just for the record, so that it is clear, I always disclose if I've had contact with something or someone, and I was at a recent, can't even think what it was now, event anyhow, and I had brief contact with Mr. Michael Vorst just on something totally unrelated. It was, can you remind me, Mr. Vorst? I can't.
Oh, was that our Rotary meeting?
Okay, that's right. I'm sorry. I go to so many meetings, I kind of get lost sometimes. So anyhow, it was unrelated to this case, had no discussion on this case, but I did want to disclose that. I don't feel like there's any issue. Any concerns?
Your Honor, before we begin, in preparing for today's hearing, it came to my attention that an objection was filed by Jack Carnahan on the 12th. This objection hasn't been served on us, but we would like an opportunity to respond and would therefore like to set over the hearing for 1 to 2 weeks.
Anyone have any objections to that?
I don't have any objection to a set over, but I haven't received any pleadings from anybody, so I don't know what that might be, what that objection might be.
All right, so just a reminder to everyone, if you file a document with the court, you must serve a copy of that on all parties. If they're represented by an attorney, you can serve it on their attorney. But you do need, and when I say serve, you can send a copy to the attorney at this stage. Different documents mean different things of how they need to get there, but something like that needs to be sent to the attorney. Okay.
All right.
Okay. All right, and then to Miss Day as well. Okay, so get a copy of that and send it to the two attorneys and Miss Day.
All right.
Okay. All right. And with that, that sounds appropriate to go ahead and set over.
Honor.
Just a second. Go ahead.
Okay. I don't believe that my client has any objection to the set over, but there's
Okay.
an issue. There's an issue regarding visitation because it hasn't been happening, even though my client has requested and provided information and that sort of thing. So I don't know if you want to take up that now. Yeah. Okay.
Yeah, we'll get to that. So in regard to the objection and responding to it, just anyone have any, I was looking at the dates here. Let's see, we're on the 15th. So I'm looking at March 7. Does that work? Any objections to setting that part of it over?
Does it
No.
need
No,
to be
Your
that
Honor.
long?
Yes, time for them to respond to your.
So sir, it's just to respond to your objection. Because you didn't serve the parties, they have a right to respond, and so make sure to get that served as soon as possible, okay?
This week.
Okay. All right, so that takes care of that matter. I do want to talk about the visitation. It was previously ordered 1 hour per week. Counsel, you were saying that hasn't been happening, or what?
Right. So January 20th, which was after the last hearing that we had and after your order, we contacted the petitioners through their counsel to set up visitation. And we offered a cousin of my clients, and they came back about 5 days later and said, no, thank you. We don't want to involve her in this thing because apparently she's a relative of the petitioners as well. So then they got back to me with a couple of names and numbers, not, I believe, non-relatives, but And about 6 days later, I got back to the council and said, yeah, that will be good. May we contact them directly to set up the visitation? And then she got back to me on February 2nd and said, let me check with my client if that's permissible to contact directly to set up visitation. So, and if there's a problem, she said, then we'll do it through council. So then 2 weeks go by and we haven't heard a thing. So my client has missed out on 3 or 4 sessions that the court ordered. And my client is concerned about that because she believes that they're stalling for whatever reason and not, dealing with my client, the mother, in good faith. And this is even after February 5th, when Miss Day wrote her report and distributed it to everybody, saying it's really important that the parents have visitation with the child to continue the paternal and maternal bond. So I'm asking that we be able to, since they haven't gotten back to us about whether or not we can contact them directly, I would ask the court to order to allow my client to contact them to set up the visitation, and that we have 2 visitations per week until we get caught up as to all the visitations that my client should have had. So that's my client's position on visitation at this point.
Counsel?
Yes, Your Honor. Those first 5 days I take responsibility for as I was out sick, and I apologize for that. Mr. Esau, as described, and I did respond to your email this morning. I did forward the request to contact directly the supervisors for Katrina. What came to our attention shortly thereafter and through the court visitors report was that she may have been entering treatment at an inpatient facility. I did offer to facilitate scheduling through Mr. Esau and I as counsel, and would have anticipated that if she was able to do the visitation and was not inpatient, that she would have reached out to Mr. Esau to talk to me. However, I will plan to follow up more aggressively in the future. I do not think that 2 visitations is warranted beyond what the court's ordered so far, especially given information that has come up since the last hearing that we plan to include as in our response to the objection. I think that could be harmful to the child. I think we would request that the order that exists currently be continued as it is, and I will work with Mr. Esau more aggressively to make sure that the visitation occurs. We don't have an objection to her contacting the supervisors directly. I just would get nervous that miscommunications could occur. That's all.
So here's what, any response, Mr. Self?
Well, it just seems to me that, yeah, I appreciate the fact that she was sick, and I failed to mention that. I apologize for that. But if there was no objection to my client contacting them, and there was yes, there was a possibility that she was going to go into treatment, but she hasn't gone into treatment yet. And we didn't say that she was in treatment and where she was. And if there's this new evidence out there, we have no idea what she's talking about. And there's nothing in the court visitors report that says that they shouldn't have treatment. And we're talking about a 2-year-old. And if they have makeup sessions of 1 per week, plus the regular session 1 per week, that's only going to be good for the child because they're going to continue to have contact with the parents. And I don't know what this mysterious evidence is that counsel's referring to yet, because I haven't seen it and nobody's told me about it. So I would ask the court to allow my client to have makeup sessions.
Stay.
Your Honor, I would just suggest, I think makeup sessions are appropriate. I would just ask that it be once a week and maybe make it for 2 hours until the missed visits is made, so that it's not entirely disruptive and it's a little easier to coordinate. It might be helpful if the court sets a date that the visitation should occur, so that we have something that is a little bit more concrete. I don't think that it should have taken, as many as much time as it has to get that scheduled. And the more time that goes that this child doesn't see her mother, the more disruptive and difficult it's going to be to restart the visits. And I don't want that to continue. So I would ask that those visits start immediately and that they go for 2 hours until the time is made up.
Here's what I'm going to do. One, I think it's taken way too much. And again, understanding someone's been sick and that always takes time, and I appreciate that. So I certainly don't blame council on that. That said, this needs to happen. It was ordered. I expect it to happen. And in regard to the makeup time, what I'm going to do is a little bit different, in that I'm going to order an hour and a half, and that will be halftime makeup, basically. Still make up the time that was lost. But here's why I'm saying an hour and a half is it is a 2-year-old. I think when you start getting into 2 hours, in some respects that can be difficult. But at the same time, I think that's a good time to start with, and then possibly just build up to that, because it seems kind of silly to start with an hour and a half and go, okay, you've had your makeup time, so now we're going to make it an hour. So, so I think at this point, make up the time. Let's see how it's going. And then Miss Day, if you can maybe see how things are going and see, does that amount of time work for that child? Less time, more time, what's better? So kind of use this as an opportunity to view and see what's going on.
Absolutely, Your Honor.
And then as far as when, I don't want to set a date certain, because I don't know the schedule of the person. I think it's understood between council now. I want this done. I want it to happen. I want it to happen soon. And that it needs to happen. But what I don't know is the schedule, and I don't want to impose on somebody willing to do a supervision if they're not available. Okay.
John, I would just ask that I be kept in the loop about when the visitations are occurring so that I can observe the visitation. I think that's going to be very important in moving forward. And then just to follow up on my court visitor report, which was filed, I am requesting that a GAL be appointed. I don't know if you want to appoint a separate GAL or transfer mine from court visitor to GAL, but I think that needs to happen. So somebody's advocating for this child.
That was my other question, is about appointing a GAL. Sir, you started to say something?
When do I get any visitation or get to say anything about it? I've had that child in my possession for like 75% of her life. I'm her primary caregiver, and I'm just getting overlooked. I mean, nobody's even gives a shit what I'm doing. Excuse my mouth. But I'm starting to really get a little bit upset about it. I haven't seen my daughter in 3 months.
Okay. Sir, at this point, I haven't forgotten you, so just hang on. So we have my question at this point comes to the guardian ad litem. I will get back to you on that matter, sir. The guardian ad litem, counsel, I think it's only appropriate. I believe Ms. Day has been acting as a court visitor. So with that, I will go ahead and appoint her as a guardian ad litem. And sir, just so you understand, court visitor has different roles than what a guardian ad litem does. Guardian ad litem does more of speaking and looking out for the best interest of the child. It's a different role. And so that's what we're talking about here, okay? So I'm going to, Ms. Day's role is going to now change to that of being a guardian ad litem. So I just need an order to that effect. So Ms. Day, it sounds like Dad is wanting some visitation. Were you including that idea with the visitations that you're talking about, or not?
I am including the father, as he has signed an acknowledgement of paternity, but I don't know that that's been adjudicated where the court is on that from a legal perspective. But my conversations with the social worker do confirm what father's reported, that he has been one of her primary caretakers and that he has acted in the father's role. I don't know where we are at in the legal process of that. So that would be my only hesitation. But I would also say that if father's going to be included in the visitation, I would be very clear that there must be no substance use, no vulgar language, no erratic or aggressive behavior of any kind. And those are some of the concerns that have been noted previously.
So let me address I have the,
Your Honor, if I may.
hold on. Just looking at the acknowledgement just to see what it has to say. Go ahead, counsel.
Petitioner is going to strongly object to visitation with Mr. Carnahan at this point in time. I would be happy to submit records to the court this afternoon for consideration on this particular issue. There's been brought to our attention by medical professionals that the child has seen recently that she was assaulted, and this is going to be part of the response that we file. However, we would request that Mr. Carnahan not be allowed to see the child until we can have a little bit of time to bring before the court what we have been told by the medical professionals. The response here, I do know that there's statutory authority for the court to limit or restrict contact between parents if in certain circumstances, and there's language about assault in there. I would just ask for this decision on this particular visitation issue to be left until the next hearing.
You're saying Jesse's been assaulted.
Oh my God, what are they going to come up with next?
So at this point, I'm not sure what has been indicated, but what I think has to be established first is paternity, and whether, and that's, I'm looking at the document at this time that he is on the birth certificate, and I don't know if there was any other issue of concern or as to that particular part.
Your Honor, we would note for the court that the birth certificate was reissued in December of 2023. There are a number of police reports that discuss that officers have searched for the birth certificate on the various databases to which they have access that did not list any father on the birth certificate. There has been question as to whether or not he is actually the father, and we have medical records in which he stated to doctors that he was not.
That was never stated as not. It was.
Okay, hold on, sir. Just a minute. All right. So here's the issue at this time is one, paternity needs to be established and clear. And I'm not saying it won't be, but before we get to next steps, I want to make sure that's clear before we start getting into visitation and things like that. So I think there's some more work that needs to be done before I grant visitation at this time. Mr. Esau, I don't know if you have any thoughts in regard to paternity.
Well, my thought would be that it's a little skinny right now. And I would agree with the court that once that's established, then visitation should be established. I'm not sure what my client's position is on that, and the court is welcome to ask her that. But this sounds like it's a shock to both Mr. Carnahan and my client. And so I haven't seen any of the records that Ms. Cowden has, so really can't take a real strong position against it, but it makes sense that paternity be established.
All right. So, sir, there has to be a process, and yeah. I want to
prescribe a remedy for this, because this is starting to get your founders. I mean, it's just, I don't understand. I'm about ready to lose my. I'm having a hard time here. Let's put it that way.
Well, I understand it can be hard to listen to at the same time. You are in court. I expect you to act like you're in court. So, you know, there are procedures we have to go through. Unfortunately, it takes time. It has been brought to light. In other words, it's something we've got to look at. You filed your objection. So these are issues that we have to look at. I also want to look at the issue of, I believe we need to get that established before I can talk to you about having an attorney appointed for you. And so I don't know if that was ever discussed before or not. That's part of the problem. So I'm kind of coming into this a little bit later in the process. So at this point, there's a couple of things. Today, we've got the guardian ad litem appointed, so that takes care of that. And then we'll set it over to that March 7th date, and we'll address the issues as it relates to your objection. But I also want to look at the issue of paternity, and I also want to look at the possibility of whether an attorney can be appointed to represent you or not. Okay. So those are the three issues that I want to look at on that March 7th date. I know that's not, sometimes the wheels of the courts don't work as fast as people want, but there are steps we have to go through. Okay.
I understand that part.
Okay. All right. All right. So I think we've taken care of what we can today. Again, I do want mom to get that visitation, and then we'll start looking at getting dad, and hopefully those CPS reports have come in.
Can I have a,
You have an attorney, so I want to make sure he's okay before you ask something.
Go ahead.
it's just, I have the paperwork to file for parentage. I just want to know if I can file it. For the
Yeah, you've got, there's something in the sound that's really bouncing or something. I'm not sure. Say again.
we have the paperwork filled out to ask the courts for parentage over Jessica to add Jack to be a legal parent. Can we file that paperwork?
Okay. You need to talk to your attorney in regard to that.
We can talk about that off docket.
Okay.
And
All
Your
right.
Honor, I just wanted to ask if Ms. Cowden or Mr. Esau would be doing the GAL order, or if that's something that you would do. I don't know how that would be done.
Counsel, can you do that?
Yeah, I can do that.
Okay.
Thank you.
All right. All right. That concludes today's hearing.
Your Honor, attorney for petitioners and emergency temporary guardians.
Kurt Ignacio on behalf of the father, Jack Carnahan.
Donald Esau on behalf of the mother, Katrina Vorse.
In council, we are on today. It indicates to approve petition to modify. We also have a termination hearing set the 21st, it looks like.
Yes, Your Honor. We filed a petition for the full guardianship and are asking the court today to approve that petition. There's been a little bit of confusion because Judge Hahn was very clear in our last hearing that at this hearing today, we were to address the issue of paternity for Mr. Carnahan and discuss appointing an attorney, but that paternity needed to be established and clear before we could talk about visitation for him. I see that an order appointing an attorney has been entered. There was also another objection and petition to terminate that was filed 2 days ago.
Yes.
There hasn't been anything filed to establish paternity beyond what had already existed, which Judge Hahn had told us in the last hearing was not sufficient. We also discussed in our last hearing visitation with Katrina Vorse. I do not believe that has happened yet. Tina Day has been appointed the guardian ad litem in this case, and we are waiting on her report as well. There shouldn't be anything before the court preventing the entry of the full guardianship, however, but if Tina Day needs more time for her report, I think we should hear from her.
Ms. Day?
Yes, Your Honor.
That's first where we are in that regard.
So I completed the court visitor report previously and then was appointed as the guardian ad litem due to the conflicts within this case. I would at this point object to entering the full guardianship until I can finish my full investigation as the guardian ad litem, because that role is very different than the court visitor. But Jessica should stay with the petitioners in the interim for that. We still have the issue of paternity where father is concerned. That has been kind of an ongoing conflict because father was not on the birth certificate at the filing, and then the parents amended the birth certificate and appointed somebody to be the father, and that has been provided to the court. That's not been adjudicated. So that hasn't gone through the process with Office of Court Enforcement or through a hearing to establish him as the child's father. He has previously denied being the child's father, and then as a result of this guardianship, came forward in that. And I'm sure Mr. Anagnostou can provide more information. My main concern at this point is it's very difficult for me to assess what is happening as far as the visitation, because visitation is not happening. It's been ordered multiple times and it simply has not happened. This child has not seen her mother in several months, and all the efforts to get that moving forward have been thwarted one way or another. Part of that is mother has refused or failed to provide a UA. I have reached out to her probation officer to see if we could maybe go that route. I've suggested that mother enter into substance abuse treatment, and we can receive those UAs, which would provide proof of her abstinence. But I don't have any information that any of those things has happened. So I'm very concerned about what's happening emotionally with this child because the interruption of her relationship with her mother. And then my second concern being some of the information provided in the response from the petitioners has raised some additional concerns. And I don't know if the court wants to go into that or not right now, or wait for my report.
Well, let's wait on that for the moment. Let me ask a couple of questions. First of all, Mr. Anagnostou, as far as the paternity matter goes, where do we stand?
Well, Your Honor, I was only recently appointed, and I reached out to my client. I haven't had an opportunity to talk with him before today's hearing, and was going to ask for additional time. I've looked through the pleadings, and there's a lot. This case has been going on since late last year. Anyway, I was only recently appointed and have not had an opportunity to talk to my client. I would ask that the court not grant basically the full guardianship until I've had an opportunity to get involved in the case and get up to speed with regards to the paternity issue.
All right, Mr. Carnahan, can you hear me? I see his name there.
So do I.
All right, Mr. Carnahan, I'm going to assume you can hear me. You need to contact Mr. Anagnostou's office today. Get in to see him right away. All right, and Mr. Esau?
Yes, Your Honor. Regarding the visitation and the UAs of my client, she does not have the funds available to produce a UA. That's been going on for several weeks now. We do have a date of March 14th for her to get in and get a substance abuse assessment and to get into recommended treatment after that. I know that's another week out, but that would give her the opportunity to get UAs if she does get into inpatient or outpatient treatment, whichever the assessment is. At this point, I think
I'm sorry, what's the date of that assessment scheduled for?
March 14th.
Okay.
So a week from today.
All right.
Yeah.
Ms. Morris, you understand how important it is that you make and keep that appointment? Okay.
Yeah. So we would oppose the entry of a full guardianship. We're not really opposed to an emergency guardianship being established because I think we're still on the immediate order was the last order entered. But it would seem appropriate at this point to at least enter the emergency guardianship, and that gives us another 60 days before we proceed with any petition for full guardianship.
Yeah, Ms. Day, from your standpoint, how far out do you think we need to be for you to do your job?
I probably need 2 or 3 weeks to finish writing my report. So if we could go out 30 days, I should be able to have my report done and circulated to all the parties between now and then.
And is that agreeable to everyone? Then let's go out about, let's say that April 4th date.
Sure.
Your Honor, I am out of town on April 4th. I apologize.
The 11th?
The 11th will work.
That works for.
Works
That's
for me,
fine.
Your Honor.
Yeah, that works for me.
All right, the 11th then, Mr. Carnahan, get in to see your attorney. Ms. Morse, make sure you make that appointment.
Thank you, Your Honor.
All right, going to number 2 on the docket, 23-4-00417-08, Jessica Force matter.
And Your Honor, I'm appearing on behalf of Hannah Cowden, who is the attorney for the guardians. And I'd ask for a continuance on this matter. I believe Mr. Anagnostou may represent the father in this matter. I'm not 100% sure. I know that the attorney is currently on a plane. And so at the last minute, they asked me if I could step in to ask for a continuance.
Okay, I wondered where he was. Okay, do I have anybody else here on the Force matter?
Katrina Vorse, the mother.
Okay, and are you the one represented by, unfortunately, it's not laid out real well on our systems. You're represented by which attorney?
Don Isu, but see, we filed the termination right before an attorney, so it was kind of everything got messed up.
Okay. So do I have anybody else present on the?
Mr. Carnahan is also here. I believe he's the father.
All right. All right, so I just need to see if you have any objections at this point here, Mr. Carnahan. I'll try to get you to unmute. *6.
And Your Honor, I'm here. Hello?
Hold on. Who's talking right now?
This is Kurt Anagnostou.
Oh, you are there.
Yeah. I'm on the phone. My video went out on me just now.
Okay. Ms. Winkle said requested a continuance.
And I agree with that, that there's a hearing already set on April 9th, I believe, or 11th, April 11th. And this could be moved over, combined with the other matters that are already pending.
Okay, and you represent which parent?
I represent the father.
Okay.
And he filed it pro se.
Okay. All right. All right.
And since I'm on the phone, I don't know if he's present.
He is
I
present.
heard that he was.
He is present. I've asked him to unmute. So I don't know what else to do, Mr. Carnahan. I keep clicking ask to unmute and it should ask. I can't, you're muted, so I don't know what you're saying. So Ms. Katrina Vorse, you are or you aren't represented?
I have an attorney. I don't know why he's not here.
I'm here.
All right, Mr. Carnahan.
Hello?
Yes, wait.
Hello?
Go ahead, Ms. Ford.
I was just going to say that he has bad service where he is right now, so that's why there's issues, I think.
Okay. All right.
But we're okay with this being set over.
Okay. All right. So
hello?
Yes, Mr. Carnahan.
Can you hear me?
Yes.
Oh, God. I don't know how to use this Zoom thing very well. So this is almost like I feel handicapped. Anyway, the only objection I have is it's been three and a half months, almost 4 months now that we've got to see our daughter. I'm asking for some visitation.
Okay. You're represented by an attorney. Your attorney has asked that it set this over to April 11, which is where it needs to get set. We can address things further at that time. Okay. So I'm going to set it over to the April 11 date at 10:30.
Thank you, Your Honor.
All right. Cause number 23-4-00417-08, guardianship of Jessica Vorse.
Hannah Cowden, attorney for petitioners and emergency temporary guardians.
For the father, Jack Carnahan.
Donald Esau for the mother, Katrina Vorse.
And Your Honor, Casey Looney is also present on behalf of the state. I'm having network issues today, so I'll have to leave my camera off.
Okay. All right.
And Katrina Vorse.
What am I'm hearing back noise that needs to stop. Okay. All right, so I did review the guardian report. So at this point, where do people see that we need to do as far as next steps?
Your Honor, petitioners are requesting today that the full guardianship be granted. There are a number of concerning issues that have arisen since our last hearing. However, as far as the guardian ad litem report, we do not have any formal objections. I do want to clarify on page 5 of the report in the summary, the guardian ad litem notes that there's a concern about the Mr. and Mrs. Vorse being permanent guardians for Jessica. The clarification we would like to make is just that they are both of retirement age and have concerns like anyone would that they will be in good health for the next 20 years. They are fully committed to being her guardians and want to do so for as long as they are able to. They are in good health and are more than willing to be her guardian for as long as they are able. As far as other concerning things, Katrina Vorse and Jack Carnahan have continued to make filings in the case without their attorneys. I also wanted to bring to the court's attention that there was a summary judgment order signed by Judge Evans on March 27th outside of this case, in which it appears they changed the child's name. We're a bit frustrated, I suppose, that these filings continue to occur without the assistance of the appointed attorneys. We haven't gotten service on any of these things that have been filed. We were not aware of this summary judgment order at all until I did a search in the process of preparing for today's hearing. Mr. Carnahan was appointed an attorney. You had previously requested that he file something to prove his paternity so that we could discuss the appointment of an attorney for him. To my knowledge, nothing has been filed to that effect. We have not had a visit done. We have not been provided a clean UA by the mother, even though petitioners have made efforts to make visitation possible once that is provided. We've been in an emergency temporary guardianship now for 157 days. And we do not see any reason that the full guardianship cannot be granted so that we don't have to continue to come back to court, as it is a drain on resources. On the subject of resources, my clients did make an effort to seek some financial support for the care of the child. And it was discovered that Katrina Vorse has been collecting that support even though she has not been in the custody or has not had custody of the child since November. We therefore request that the full guardianship be granted today.
Mr. Anagnostou?
Yes, Your Honor. It is improper to grant the guardianship. To get a full guardianship, they would need to do a docket notice on the trial assignment docket, the universal trial assignment docket, get this assigned for trial. This is not a default case. My client has responded to the allegations, and so from that point, we would need to have a trial so that witnesses can appear and testify on behalf of the parties, the parents, and guardian ad litem. I mean, it's inappropriate to grant a full guardianship when there's been a response and an objection, and the matter is being litigated. So if counsel wants to grant a full guardianship, she needs to do a docket notice on the universal trial assignment and get this assigned for trial so we can go to trial on the issue of whether this guardianship should be granted. With regards to the other allegations, they can't continue for some reason to raise this issue with regards to paternity. My client's name's on the birth certificate. He's listed as the father. So he's got to get a blood test to prove that he's father when he's on the birth certificate. I've just never heard of that. But that's my recollection is my client has filed the birth certificate that indicates that he's the father of the child. If they want to challenge, I don't know how you would challenge paternity. Some third party come in and say, no, we're going to set that aside. I mean, I guess if they have a blood test from somebody else that shows up that they potentially are the father, we could get into some kind of dispute over parentage. It's not before the court. It's not before the court. What's before the court is my client is the father. He's listed on the birth certificate. And what he wants going forward is visitation. He wants to see his daughter. He needs to. We have submitted yesterday, he had brought in some reports. He is in full treatment. We've provided those to Miss Day. What we were here to request today is that the court set up, and what he's willing to do is paid for supervised visitation. Let's set it up with Miss Fellow's organization, Reconnecting Families, or potentially finds another organization that does paid supervised visitation, but he wants to see his daughter. We need to get that, going. So that's what our request here today is. He's responded to these allegations and needs to set up time to with his daughter, is willing to do paid for supervised visitation while he goes through the treatment program. He's provided the treatment information to the guardian ad litem, he wants to move forward, protecting his rights as the father of this child.
Okay, Mr. Esau?
Thank you, Your Honor. I concur with Mr. Addict. My client has the right to a trial on these issues. She's contested the emergency guardianship at least 3 times, most recently last week, on her own. And she has a constitutional right to cross-examine the witnesses and to assert her parental rights. And at this point, she requests that this case be set for trial. We're not making any ground in temporary guardianship, that's for sure. And we need to move forward. My client has been doing some outpatient treatment. We don't have any UA reports yet, but as soon as we do, we're going to be asking for more visitation as has previously been set up. Thank you. I have nothing further.
Ms. Looney?
The state would have nothing to add this time, Your Honor. If we are setting for trial, we would weigh in on child support at that time.
All right, and Ms. Day?
Yes, Your Honor, thank you. I would agree that the parents have responded and that this matter needs to be set for trial before granting a full guardianship. There should be a full hearing with witnesses, etc. I did receive information yesterday from Mr. Carnahan's treatment, which has included UAs and his beginning process of intensive outpatient treatment. I also received information from mother's treatment, so I know that she is in treatment, but there have been no UAs information provided as of this time. And the prior order of the court was that mother must have a clean UA and then visitation could begin. I have no objection to supervised visitation for either of the parents. I think that's appropriate. I would ask the court to maybe consider an alternative to paid supervision simply because of the parents' financial status, that puts them in a significant hardship if they have to pay $50 to $70 per hour to visit with their daughter. They have not had any contact. Jessica has not had either parent since she's been placed with the petitioners, with one short visit with mom back in November. So I have expressed to the court a number of times that visitation should be happening, must occur, and we need to be able to move that forward. Mother has not provided the UA, and so that was the order of the court. So that should happen first for mother. But we need to get this moving forward, and there does need to be some supervised visits start. This child is losing her primary bond with her parents as a result of what's happened in this court process. And we have to find a way through that for Jessica's sake.
Ms. Cowden?
We have not been served with any of the filings that have occurred over the last month. I am concerned that the parties will continue to try and circumvent both their attorneys and the court, as we have seen so far. I am also concerned about the summary judgment order that we were not aware of. I believe that had Mr. Esau or Mr. Anagnostiu been aware of it, they would have brought it to my attention. I have those concerns. I am also concerned about the issue of visitation for Mr. Carnahan. We had been instructed by the court to discuss his visitation as well as the appointment of his attorney at today's hearing. This did happen in between time. I do not want to have continued procedural issues draw this out more than is necessary. The child is doing well in the care of Michael and Carla Vorse, and the full guardianship is appropriate at this time. I think it was discussed in an earlier matter that the emergency temporary guardianships are only supposed to go as far as 120 days, and we are beyond that now.
So you said there was a summary judgment. I don't see one in here. When did you say it is?
It was signed on the 27th of March, and the case number is 24300158-08.
Okay, that's not on my docket, so I'm not sure what that is.
It was filed outside of this case, Your Honor.
It's a domestic case.
It's a summary judgment order. It has parentage next to the title. It does not acknowledge this case at all. It looks like what they were attempting to do was to acknowledge parentage. I will remind the court that the birth certificate that was filed into this case was reissued in December of 2023, I believe. And our concern had been that that was an acknowledgement of paternity.
Yes.
There were a number of concerns we had about what had occurred while the child was in the care of Mr. Carnahan and Katrina Vorse, and had wanted to allow the Progress Center to continue to work with the child and for the child to seek counseling. These things have gone on. It just seems frustrating for all of us involved. I think that there can be orders going on outside of this case that affect what's going on here without it, I don't know, being served or known to us.
Okay, well, in regard to that matter, I'm not sure what to even say or do. I don't know how that could even be monitored other than what you're seeing. Whatever case may be happening, if you're not a part of that case, what is that now? People, please mute your connections until you are called upon, please. All right, so I don't know what to tell you on that at all. That's not something I can monitor, or I even have any ability to go, and orders not on the docket. If you need to bring a motion in a separate case, that I'll leave that to you. But as to what we have in front of us today is the minor guardianship. But I don't even know what's going on in the other case to even know for sure what the court would even order. As far as, you know, Mr. Carnahan being the biological father, I don't know that there's been any proof at this time to say if he's on the birth certificate. I don't know what else can be done at this point other than bring it up at an evidentiary hearing. But to just come in with the idea, I'm sure the child is doing fine with Mr. and Mrs. Force. I'm not questioning that, but at the same time, this is about ultimately a return of the child to the parents in the long run, if everything is followed through. So even though it may be going well and, you know, for the child, that doesn't mean that that is necessarily the long-term what happens here. So there has to be the visitation that needs to occur, that's been ordered, and that needs to happen. So as far as, let's see, the visitation, let's see, with mom is to have the UA, that's to occur first, correct, Ms. Day?
Yes, Your Honor, that was the previous order of the court. Both parents are now in treatment, so I would not object to visitation moving forward.
Okay. So that visitation does need to move forward and it needs to happen. In regard to the idea of just making a decision of granting the full guardianship, and do you have some authority that says that I can just do that? Because I just can't imagine anything saying that.
I suppose the concern is just that the emergency temporary guardianship just is continuing to go on and on. If setting it for trial is necessary, then that's necessary.
Okay. It needs to get set for trial so parties can be heard of whether a full guardianship needs to occur, that the parties have a right to have their counsel present. So that's what needs to happen. It needs to be set for trial. So two things. One, the visitation needs to occur and as recommended and ordered. And then two, the matter needs to get set for trial.
Your Honor, would you like another extension to be entered while we're
I
waiting?
do. It does need to happen.
Your Honor, can we have something in the order that indicates that the visits must happen with a certain frequency, some sort of way of moving this forward, because it's been ordered and it just isn't happening. I would ask that we have maybe 1 or 2 hours supervised. We can come up with an agreed supervisor and have a date certain that this starts.
Ms. Cowden?
I would agree with that request, Your Honor.
Your Honor, we have agreed to supervisors. We've already discussed who they are, and that has been agreed to. We also did have in our prior orders a frequency listed. I need to refresh what it was.
All right. So that's been done, Ms. Day, I think. I don't have it sitting right in front of me, but I was pretty sure it'd been done.
I thought it had been as well, Your Honor, but it just hasn't moved forward. So I guess my asking at this point is, now that both of the parents are in treatment, can we start with visits this week for both parents based on that order?
Okay, it needs to happen, bottom line. And again, as guardians, that means that you also have to participate and be available for the visitation to occur. So that visitation needs to occur.
And Your Honor, we have made efforts to be available. The order that has not been fulfilled is the clean UA aspect, which we have been waiting on the mother to provide to us prior to visitation per court's order.
And that does need to happen. Okay. All right.
Well, that's an issue, Your Honor. My client has provided UAs to his treatment facility, and they show positive for drugs, but he's in treatment and working on those issues, and should be allowed to have supervised visitation while he's going through that process.
Okay. I've already ordered on this. I'm not going to change what I've already ordered. So I expect a clean UA when visiting that child.
Yeah.
Okay. So set it for trial.
Thank you, Your Honor.
Thank you, Your Honor.
All right, do you want to set a review time, a month out or something to make sure that everything's been done?
Can we just set it for the trial assignment docket from this hearing?
That's fine. Oh, from this hearing? No. Needs to be noted up.
Okay, thank you, Your Honor.
All right, so I'm gonna set it out a month, just to follow up and make sure things are happening. So I'll set it on to May 16 at 10:30 a.m.
Your Honor, my office has previously been preparing the orders extending. Is that what you would like us to do again?
Would please.
Thank you, Your Honor.
Thank you.
I was able to find it once I had the case number, and while there was a summary judgment in the pro se case in April, which was around the same time as the hearing we just watched, there were no actual hearings in that pro se case until August 2024, and those hearings were on the family law docket and not the minor guardianship one. I'll add those hearings at the point in time when they occur to this video.
All right, number 3 on the docket, 23-4-00417-08, guardianship of Jessica Vorse matter.
Your Honor, Hannah Cowden for petitioners.
Katrina Vorse, mother.
Ferdinand Ignacio for father, Jack Carnahan.
Tina Day, guardian ad litem.
Donald Esau for Katrina Vorse, the mother.
All right, and I see your clients are on as well. All right, so hold on. So last time I believe we were looking at the idea of the trial being set. Did that happen, or what's going on there?
Yes, Your Honor, we had our trial setting yesterday. Trial has been set for the 30th of September and readiness for the week before.
All right. All right, so with that, Ms. Day, how are things going, or?
Well, Your Honor, they're not going very well at the moment. We haven't made any progress in addressing visitation with mom. I did get information yesterday at the trial setting that she will be prospectively entering inpatient treatment. So I'm waiting to confirm that. The child has still not had any visits with mother. Father has entered treatment. He is changed his residence to the community house. I think you've seen the documents that have been filed with the UA levels that have been titrating down to a place of being clean with the exception of marijuana, which, as Your Honor knows, takes time. He's requested visitation. At this point, that's not been agreed to by the petitioners. And I think Ms. Cowden can kind of address their position on that. It is my position as the guardian ad litem for Jessica that she is entitled to visitation with her parents. Mr. Carnahan has signed a paternity affidavit. My understanding is that's been adjudicated under a parentage matter. I don't have access to that, so I can't see that. You would have to look for that because parentage actions are sealed and I'm not appointed in the parentage action. But my understanding is that has been adjudicated and he has been acknowledged as the father under a parentage action. So as the father, he should be entitled to visitation. Jessica should be able to see him. There have been some more recent allegations that have come to limit his contact based on some other concerns, and I'll let Ms. Cowden address that, and then I'll respond if the court wishes to have that information.
All right, Ms. Cowden.
Thank you, Ms. Day. Yes, Your Honor, we submitted a response yesterday to Jack Carnahan's motion to compel visitation. First of all, we'd like to seek some guidance from the court regarding the issue of paternity. The court ordered during our February 15th hearing that Jack Carnahan prove paternity before we would talk about visitation. I understand parentage and paternity are two different things, and a child has a constitutional right to accuracy in a determination of paternity. We would just like to know what kind of proof of paternity the court is looking for here. paternity action versus here are different. So we just request some guidance on that. We only objected to visitation before we talked to you again, because that was the court's order and we would like to see the order followed. The order's been the same since the February 15th hearing. We would like to get that figured out before visitation happens. We'd also like to request the conditions that we've had that are similar to what we have for mom, which is that we have a clean drug test, it's supervised, and the paternity be proven before Mr. Carnahan visits with the child. We also believe it would be appropriate for there to be a period of time in which we can see sobriety before visits begin, given that he's told the court that he's had a 30-year history of substance abuse. I think that's all of our requests today. Just a bit of guidance from the court would be helpful here.
And remind me, mom is getting, tell me what mom's visitation is. I can't recall.
Mom's visitation is 1 hour per week with a 24-hour clean urinalysis. This hasn't been exercised by mom. The last attempt that we had to set something up was, I believe, the 16th of February, and mother canceled, and we haven't heard anything about it since from her side.
All right.
It was also the first that we had heard yesterday that she plans to enter inpatient treatment, and we would love to request some documentation that treatment has been entered when that does occur, just to see that enrollment has actually happened and it's going on.
All right. Mr. Anagnostou, you represent Dad, correct?
Correct.
All right. So I read your motion in regard to visitation. Before I turn it over to you, the one thing that I wanted to get clarified, let's see. Is in regard to the paternity. Paternity has been established in regard to the father?
Yes, Your Honor.
Hold on, I'm hearing a train rather
Right.
the fun of working by a train.
Yeah, we're hearing it too, so.
Okay, it'll be just a moment here. All right, I think we're good. Go ahead.
Yes, Your Honor. Somewhat upset with regards to the petitioner's response to this motion. They bring up yet again paternity. And they supply a transcript of a hearing that happened before I got in the case. And they keep this paternity issues like a dog with a bone. I mean, they just keep bringing it up. At the hearings that I've been in, and I've explained it to Your Honor, there's a birth certificate that has my client named on it, and he actually filed it before I got in the case. It's court document number 45. It's a birth certificate. He's the father. The state of Washington says he's the father. Why they keep bringing this up and saying, well, we got some paternity issue. If they think there's another father out there, I assume it's not them, but if they think there's another one, there's a process that they go through to bring an action before the court to challenge paternity and to reestablish parentage. But at this point, the state of Washington says my client is a father. We've supplied that document to it, yet every pleading we get before us, it still says paternity. He's got to stay. He's done that. He's the father of the child, and we need to go forward with the important issues, which is my client having residential time with his daughter. The second issue is with regards to
hold on. I'm going to ask Ms. Cowden on that. I see the birth certificate. It's been filed. He's named on there. So I'm trying to figure out what the issue is in regard to paternity.
Yes, Your Honor. At the February 15th hearing, that birth certificate had already been filed, and the court was of the position that that wasn't quite what we were looking for because the birth certificate was reissued in December. of 2023. The child was born in September of 2021. Like I mentioned, paternity and parentage are two different things. And the establishment of parentage happened in an action outside of this action that we were never notified about. It was just my legal assistant saw it when she searched the child's name on Odyssey and brought it to my attention. Otherwise, we would never have known it happened. I don't believe, and you can also see my response in the case law in there. The parentage action doesn't give us the paternity proof that we were looking for this. I did bring up the other action last time we were in court, and there wasn't enough information before the court to discuss it in regard to the paternity issue at that time. But the orders that we have established that are the last two, and even three maybe, I would have to go back and look, but certainly for the March 7th and the April 15th orders entered, the paternity issue is specifically addressed in the order that the court wanted to prove that before we talked about visitation for Mr. Carnahan.
You said on February when?
So the hearing that we made that decision was February 15th, but I know for certain that on March 7th, there was an order entered that had that language, and the language in the April 15th order is identical, and that's been our most recent order extending.
And I have a very big issue with regards to those entered orders. They were, Your Honor indicated that they would be entered upon presentation. There was no presentation at all. There's no signature line for me, the father's attorney, nor the mother's attorney, Mr. Esau, or the guardian ad litem. And somehow these were just submitted to the court and have carried over from before I was involved in the case. And had I had an opportunity to see these orders before they were entered, I'd say, hey, wait a minute. We've already decided paternity. That's a dead issue. And my client is entitled to residential time. We've always been talking about my client's residential time since I've been in the case. And the court said my client could have residential time if he had a clean UA. But now they're saying, the court said, no, he doesn't get any visitation at all. It's not set forth because they've been presenting orders behind my back to the court. So I think, again, the paternity issue is a dead issue. The state of Washington has indicated my client is the father of the child. If they want to challenge that, there's a process for that. They can go through and do that. They need to have somebody come step forward to say, I'm the father. And as far as we've known, nobody has done that. So my client is the father. He has all the legal rights and constitutional rights. You know, they're stomping on him, saying, raising some issue regarding paternity without ever raising an issue about paternity. Just saying, well, we have some kind of concern about paternity. What? You know, do what you need to do legally. My client is the father of the child. He's been declared the father. And then with regards to visitation, it's my understanding at the previous court hearings, we absolutely were talking about my client having visitation so long as he had a clean UA. He submitted all sorts of documents, but and we filed one this morning from his counselor. He's in full treatment. He's at the community house. That's a clean living environment. I'm sure the court's all aware of the community house requirements. He's in total compliance. And his counselor, as of yesterday, in their letter said, Mr. Carnahan's decreasing THC levels reflect a cessation of marijuana use. He's not using marijuana. And it unfortunately shows up in your system for a period of time. The court's aware of that. We want to set visitation. We want, it's our understanding, the court already said he could have visitation as soon as he had clean UAs. He's provided a slew of those. And we want visitation and it needs to be set. And Mr. Vorse, the petitioners, are just going to stand in the way and raise weird issues about paternity and my client's past and not go forward with what should happen here. My client's constitutional right as a parent, he's clean, he's in a clean living environment, and we need to get to the next step. We need to start the process of him having visitation and ultimately custody return to my client.
All right, hold on here just a minute before anything more. I'm going back to February 15. And let's see. So I said on February 15, that at that point, it was really not known about the paternity part of this. And I ordered paternity needs to be established and clear before I ruled on visitation for the father. So that was February 15. And then I believe the next one is March 7. And I think at that point, I'd also said that the father needed an attorney, which is where Mr. Anagnostou came in. And then at that time, Mr. Anagnostou responded, doesn't have an updated paternity has been established. I think you were just new into the case. Request additional time. So that was done on March 7. And then looking for the next, looks like April 11.
Right.
Is at that time, court ruled the summary judgment order is not in front of the court in this case. There is no proof to say that Mr. Carnahan is not the father. Visitation needs to occur that has been previously ordered. Mom is to provide the UA first and visitation to move forward as recommended and ordered. Full guardianship needs to be set for trial. So at that time, at least the minutes are saying there is no proof to say that Mr. Carnahan is not the father. So I'm not sure where it got to the idea that I ruled that he wasn't the father and didn't have a right to visitation.
Your Honor, I believe the April 11th hearing, you also had stated that you didn't want to change the order as it was at the time. The paternity issue, the child has a constitutional right to accuracy in that determination. Petitioners only seek to look out for the best interests of the child. The other concerns that we've brought up, as you are aware, were concerns of assault and her being around drug use. If he is successful in seeking treatment and being clean and is the father, then great. You know, we'll work with it to set something up that is supervised and so that the child is safe. We just want to make sure that we're protecting the child's interests here, including her constitutional interests.
So, Mr. Anagnostou, I apologize. Some of what you were saying, that your client is in treatment at this point, correct?
Correct.
Okay, and is it outpatient treatment then, I take it?
It is.
Okay, do you know what the stage is that he's at?
I don't know. Miss Day may know. I mean, I've sent all the reports to her and
I do know, Your Honor. He is in the intensive outpatient 3 times a week for treatment, which includes medical assisted, as well as mental health counseling through the community house and case management and parenting classes. And those have been confirmed with the community house.
Okay. So, Mr. Anagnostou, go ahead. I cut you off earlier.
No, I was just with regards to parentage, they say the child's right to an accurate determination of parentage. That happens in the parentage action. That doesn't happen here. That's already happened, and my client has been named the father. And so, like I said, they just continue to bring up this issue. We need to, drive a stake through his heart and, finally, get it to be a dead issue, and go forward with my client having residential time with his daughter. He needs to reestablish the relationship. And he understands, and we're prepared to have a supervised visitation. We just need your honor to order it because they are not gonna cooperate or offer anything. And we have a supervisor prepared to supervise the visits. And
Who would that be?
It's the alcohol and drug counselor out of Toutle Lake School District. I know her first name is Leanne, but my understanding, Miss Day has interviewed her and talked with her as being a potential supervisor.
Yeah. So I'm just focusing obviously on dad at the moment. So Miss Day, can you tell me what your recommendations are as far as dad?
Yes, so my recommendations are that we start with visitation once a week for 2 hours, supervised by Leanne Couch. That can be either in Castle Rock, which is where petitioners are, so there's less travel for the child, and the schedule is flexible to accommodate that. And then it would be my ask that as those visits would progress, to monitor potentially at the community house. But to start with, I'd like to have them by Leanne Couch, either at the Longview Library or at the Vault in Castle Rock, which is, I don't know if you're familiar with that, but it's a coffee shop bookstore with a play area for children, someplace that's been vetted as a safe place for children to be. And I would be able to observe in either the library in Longview or at the Vault once we have that established.
Your Honor.
Ms. Cowden, go ahead.
We had previously, the parties had previously agreed to supervisors that were not the one that Mr. Anagnostou just mentioned. I was wanting the court to let us know if that agreement has changed or if we need to revisit that, because we have not had a chance to agree to that supervisor. If they're a professional, we can figure something out and learn about it. I also apologize, Mr. Anagnostou. I just want to clarify that the paternity concept, those statutes are different than the parentage statutes, and those standards are different, and none of them are part of the guardianship statute. And so the guidance I was seeking from the court on that is how those things apply and if they do. If he's not, he did, and you can see in the exhibits attached to the declaration that we filed last Friday, there were a couple points where he told one of the child's doctors that he was likely not the father and he was not on the original birth certificate. So we would request that the orders that we've been existing under just be followed in regard to that. As far as the supervisors, if we're going to use a professional supervisor, we would just like a chance to review their credentials as well.
So Ms. Day, is it a professional supervisor or is she just somebody that?
She is a professional, but not a professional supervisor. She's a professional substance abuse or substance use disorder counselor. She's been employed for many years at the Toutle Lake School District. I've worked with her on previous cases that I've worked with, and she is available to provide eyes-on supervision for Mr. Carnahan and Jessica.
All right. Anything else on that in regard to the father at this point?
Your Honor, in our response from yesterday on the last page there where I list our requests, we just also would request that there be a period of 60 days of sobriety before visits begin, so that we aren't bringing the father back into her life and then taking him out again if something happens. Because we need him to commit to being sober to protect her interests there. Her emotional state is already very fragile.
Ms. Day?
Your Honor, I appreciate that, and I don't often disagree with that type of a setting in a situation where there's been kind of this ongoing back and forth. But this child hasn't seen her parents, either of the people who have been her primary care providers since she was placed with petitioners. And I think that it's disingenuous to say if mom provides a clean UA, she can have visits immediately, but father can't. My conversations with the social worker who was involved at the beginning of this case, just before the dependency petition was to be filed, indicated that Jessica was very bonded with both of her parents, specifically with Mr. Carnahan, and that she had no safety concerns outside of the home environment and the substance use. I'm requesting that we begin this process. I feel like I appreciate all the work the petitioners are doing to help this child and to provide and care for her. But I think we're at a place now where this child needs to be able to have a relationship with her father. If Mr. Carnahan is not successful in staying clean and sober and following through with this, then that will become evident very quickly. But in the meantime, this child has been ripped out of the only people she's known and placed with people who are virtual strangers with her for more than 6 months. She needs to have contact with her parents. And I've asked for that many, many times, and we need to be there. I'm appreciative of having clean UAs in order to visit, but I think saying 60 days clean, that's not even required in a dependency, let alone in a guardianship.
Mr. Anagnostou, anything further?
Just briefly, council mentioned something about an agreement as to supervisors, but their position has always been that my client doesn't get to see the child at all. We've never talked about an agreement. We can't agree that my client's the father, despite the state of Washington saying he is. So there's no agreement between my client and the petitioners. This needs to be court ordered, or else it's not going to happen.
Here's what I'm going to do in regard to the father. One, it's about what's in the best interest of the child and figuring out what will serve that child as far as whether or not it's a good thing to see a parent or not. As I understand and I appreciate the concern, but similar to what Ms. Day was talking about, even in a dependency, we would not be looking at such restrictive requirements before having them have the contact, at least what's being talked about. So it's supervised visits, and I am going to order that it's a supervisor that Ms. Day has said. One, Ms. Day has interviewed this supervisor, but more importantly, that supervisor is trained. And if that supervisor is trained, they're going to be able to identify and recognize whether or not somebody's under the influence. And so that's the big issue that the court is concerned with. And so I do want the clean UAs. The clean UAs must be, are you asking for how far in advance have they been doing it, Ms. Day?
The UAs have been clean for the last 2 weeks of all other illegal substances, not including marijuana. The marijuana continues to titrate down. I haven't seen the ones that came through today. I think it's almost 0, but I haven't looked at them. So I have no concerns as long as the marijuana levels stay down and there's no new substances. And those UAs are being sent to me upon delivery as soon as they occur.
Okay. So the UAs must be clean of all substances, that the marijuana must continue to titrate down. If in fact the marijuana starts going back up again, then the court's going to stop the visitation until the matter is back before the court.
Your Honor, may I ask a clarifying question?
Yeah.
The UAs that or the test results we've been receiving up to this point, I understand are self-reported. Is there supervision when he's taking these tests?
Yes, they're professionally done at the treatment center. So yes.
Okay. We had been concerned that there was a positive result for fentanyl on April 17th. I understand. Of course, I'm not a scientist, so reading some of these results, I need to seek clarification, but that was concerning to us because both Ms. Day and counsel for Mr. Carnahan said that he was clean and compliant, and we were seeing different results in the test. But that's all I wanted to note for the record.
Okay. So, and the visitations will occur at the 2 places that were identified by Ms. Day, the vault, and what was the other one you said?
The public library in Longview.
Okay.
How many hours in frequency, Your Honor?
So 1 time per week, 2 hours per week with the Leanne at the vault or the Longview library.
Your Honor, may we request that when the mother enters inpatient treatment, as indicated by her counsel, that we receive some documentation to that effect.
Yeah, so let's talk about mom, because I've not really addressed mom. I've just addressed dad at this point. So go ahead.
Before we leave,
Oh.
Ed, Your Honor, I was just wondering, 2 hours per week, are we gonna review this at some time in the future?
I will.
Yeah, he's
And-
gonna want to expand that.
Yeah, you can always bring your motion to expand it at some point, and we'll take a look at it and see where he's at in treatment. But especially when he's at the level that he's at, this is what it's going to remain at. If he starts going to the lower levels, then we can take another look. But as long as he is at the intensive outpatient treatment level, then it will remain as currently ordered.
Thank you.
All right, Mr. Esau.
Thank you, Your Honor. First of all, the mother would concur with your ruling and with the visitation request by the father. Regarding her situation, as I reported yesterday, she's going into inpatient treatment. This is not really voluntary because she's being monitored by the Department of Corrections on her, her felony conviction. So she either goes to inpatient treatment or she goes to jail and or prison, whichever would apply in that situation. So she doesn't have many choices here. And the last time I spoke with her, I believe it was the day before our hearing yesterday, she was willing and ready to go to treatment, which she has to get her paperwork in by Friday. And she will be signing releases of information to the attorneys and to Miss Day. She's fully cooperative, and I can tell a difference just in the way that she was talking, how she brought the subject up, and how she was going to be doing this. So I think that's good news for everybody, including the child. But obviously she won't be able to visit the child until after treatment is done. And we're not sure yet if it's 30 days or it's going to be up to 90 days. It could be anywhere in that, range of treatment. It just depends on the treatment facility and the Department of Corrections and how they want her to take care of this issue in her life. So that's what we have to offer at this point.
Is she on a DOSA then, I take it?
I did not ask her that, like a methadone treatment, Your Honor, or?
No, DOSA is the name of the criminal type of sentencing that was.
Of course. I'm sorry, I misheard you. I haven't seen the document that of her sentencing. That would probably be a good idea for me to get a hold of that so I could answer that question in the future.
Okay. All right. In part, I was just wondering how much supervision was going to be occurring by the court. All right. So with that, mom's visitation has already been ordered. Anything else as to that, Mr. Esau?
Not at this time. Obviously, that'll have to be suspended until she gets out of treatment. And we plan to keep everybody updated as to whatever information is going to become available as she goes through treatment. So, yeah, so whatever the petitioners want in terms of verification, then we're happy to provide that because that's obviously coming from the Department of Corrections.
Okay. All right. So with that, anyone else in regard to mom at this time?
No, Your Honor.
No, Your Honor.
All right. So counsel, if you could go ahead and prepare an order, Ms. Cowden, I would ask you to circulate it to Mr. Esau and Mr. Anagnostu, and then Ms. Day. And then submit it to me for review and signature.
Ms.
All
Cowden,
right, so-
if you could speak with your client so we could set a day for the visit so that I can adjust my schedule around so I'm able to observe, I would appreciate that. If you can do that off docket.
I can do that. Your Honor, for clarification, is the language changing that has been in the order? Let me see, which page is that on? I think it's one of the last pages of the order. I apologize. I had it in my hand a minute ago. Bottom of page 3, because we've been using the court's established forms. There's a box number 8 where we've had the same language in there the whole time so far. Is that language changing today?
Let me get back to it. I was looking at it a minute ago.
Yes, would be my answer.
So to clarify, I believe there was some issue. One, Mr. Anagnostou wasn't, when he came on board, certain about the paternity. It hadn't been real clear at that point. And then the birth certificate, obviously, at this point, he's presumed to be the father until he's disestablished as the father. And that has not occurred as far as I understand. So let's see.
It's, as Your Honor indicated, 2 hours per week visitation to my client. And that used to provide updated treatment and urinalysis. We don't have a problem with that.
Okay. So that part should be added.
I'm sorry.
Go ahead.
Do you want in this part of the order the suspension of mothers until treatment is completed?
I believe that was how it had been rolled.
Okay.
So that'll remain.
Make sure I'm putting the correct in.
I'm sorry, did you indicate that mother's visitation wouldn't start until treatment was completed?
Well, it shouldn't be treatment, inpatient treatment.
Yeah, if she's an inpatient, but once her UAs are clean, she may be even able to have visits inpatient if she's in 90 days.
Right. Yeah, I was just clarifying. It should say inpatient treatment. Mr. Esau?
I concur with that, Your Honor. Yes.
Okay.
Mr. Esau had said something about they'll need to be suspended. I wasn't sure what the rules were for the particular inpatient treatment that she's headed to.
I don't think we know what's I've heard 30 up to 90, so it's hard to say without DOC and what they have for their requirements. That I don't know.
Okay, I will circulate the document before submitting it to the court.
Okay. So go ahead.
I'm just thanking counsel for circulating the document.
Okay. So my question is, we can do reviews if you want to do more reviews. I hate to keep bringing everybody back just to, without having an issue necessarily to look at. So do you want to set this out a month, or what would you like to do?
Your Honor, with specific guidance from the court, petitioners would request that we don't continue to do reviews prior to trial. It's getting very expensive for my clients, and they're paying for it privately and have been faithfully paying their bills. That's getting to be kind of a lot. The other parties have appointed counsel and are not worried about that. But we would appreciate fewer reviews. Compliance reviews, I believe Ms. Day mentioned that father's compliance can be reviewed outside of court. And if we need to revisit after the mother has done treatment, that's fine. Otherwise, we could just kind of discuss the same things over and over until trial.
Okay, it sounds like September 30. So do you want to set it on for October 2nd, or excuse me, 3rd?
That works for us.
Mr. Anagnostou, does that work for you?
That's fine, but I wanted to respond to the request for reviews because I would like to have a review set up in a month to see where we're at going forward. My concern is to date, we've not been able to agree on anything. My client is going to continue in treatment. This is my wishful thinking, but he's going to want an expansion of the visitation. And I believe that would be justified, and it would be better to set it for a review. And then if council and I can agree on something, we come to court and say, well, we've agreed to the expansion. But I'm just concerned that there won't be any agreement.
Mr. Esau?
I think we're neutral since nothing much is going to be happening with my client, albeit the treatment. But I'm not opposed to either position at this point. Of course, we wouldn't want to review once my client is, discharged from inpatient treatment, but we don't know when that's going to be. So I would just, I guess I really don't have a position on this at this point.
So what I'm going to do, unless somebody else has something, I'm going to set it to October 3rd at 10:30. And I'm doing that because you can always note it up, Mr. Agnostu.
Sure.
If something's not happening, you can note it up.
Okay. I understand.
Okay. All right. That should take care of that matter.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
I'm going to start with number 2 on the docket, 23-4-00417-08, the guardianship of Jessica Vorse.
This one?
Your Honor, Hannah Cowden present for petitioners.
Kurt Anagnostu on behalf of the father, Jack Carnahan.
Okay.
Mike Morris.
Donald Esau for the mother, Katrina Vorse.
Anyone
Pay
else?
for child support, Your Honor.
Thank you.
Tina Day, guardian ad litem.
What? Is it a spreadsheet you're looking at?
All right.
Yeah, the AR. This is all the statements
So-
that are gonna drop to the patient. That's how I caught it.
I keep hearing a lot of conversation. That conversation needs to stop, please.
I'm looking at the financial clock.
All right. So I received 2 proposed orders regarding the hearing and the ruling. I don't know. I believe Mr. Esau and Mr. Agnostu had agreed on that. I don't know if others had agreed on that.
Your Honor, there's a couple places I'd like to ask for clarification. The copy of the proposed order I received from Mr. Anagnostu, he had marked out may in favor of shall. We're fine with that. He'd also marked out where I'd written prior to each visit taking place. I had included that because that was what we had agreed to for the mother previously and what had been ordered. I just wanted to ask for clarification. Right now, we're receiving UAs at a rate of about every 3 weeks. Is that, if that was the court's intention, that's fine. I just wanted to know what the court's intention was.
Sure.
for that.
I understand. Anyone else want to be heard on that those particular issues?
Yes, Your Honor.
Oh,
Go ahead, Ms. Day.
So it was my request to take out the language that said prior to each visit taking place, that a UA would occur. The UAs are occurring from 2 different locations, 2 different treatment centers as random. So they're occurring basically one every other week at one place and one every other week at the other place. One of those locations is observed, the other one is not. But they are being provided, they are clean. And as soon as the levels come in, I provide the levels that are sent to me from each organization. I don't think it's reasonable to have to take a UA with levels every day before the visit and then try to have that information back before a visit can occur. That just simply isn't logistically something that's able to be done. My position is whether it's father or mother, as long as they are in treatment and providing the UAs and in compliance, there's not a need for an additional cost to the parents to provide another UA independent of what's already being provided by their treatment providers.
Okay.
And that's my comment as well, Your Honor. We will provide the UAs as my client takes them, but to have to do one right before a visit and he paid for it, you know, he's at the community house on limited funds, but we're providing all the UAs that he is taking as timely as we can.
Okay, anybody else?
Your Honor, I concur with counsel and Ms. Day. My client obviously is in inpatient treatment. She's completed her first week. She is clean and sober, and they are testing her. So I have a release of information on file from my client, so I'll be getting that information routinely. So I think that not having to take another UA prior to each visit is superfluous under these circumstances.
All right, anyone else? So in regard to that, the language that has been deleted prior to each visit taking place, that seems appropriate so long as the UAs are being done through treatment and wherever else that they're being done. I do want the UAs to be continued in that manner and the information being provided as talked about. And as long as those UAs are clean, the visitations will continue. So if they start showing positive, then the visitations will stop. That's bottom line. So I expect clean and sober, and so that part of it does need to be a part of the requirements.
And that's contained in the order on the next line, and we haven't deleted that.
Somebody deleted as will be required for visits to continue.
On my version.
I also have this one that
Oh, yeah. I did take that language out. My concern was the requirement to do a UA before a visit and then get the information to counsel. So my understanding of the way this works is it gets terminated if he gets a UA and we turn over all the results and it shows positive.
I believe, at least as I phrased it, the requirement for visits to continue was in relation to the compliance, so his being clean.
Okay, so again, visitations will continue upon remaining clean. And
Right.
if not, needs to come back before the court.
And then I had a change, Your Honor, with regards to the once a week, 2 hours per visit in a public location. This implies that during the hearing, we discussed increasing the visits as he established a relationship with his daughter, and you said we could bring that back on motion. And this order implies that we can't, that it's going to be no more than once a week, 2 hours, basically until we have our the review hearings that's currently set in like October, I believe is what we were saying. But so I wanted to delete that and say that it was starting at once a week, 2 hours per visit, because that's my understanding of your ruling. This is just starting the visitation.
Anyone else?
Yes, Your Honor, if we're not going to include the words no more than, then we would prefer to also not include the words starting at, just so that we have clarity at what is happening until something else is ordered.
Anybody else? All right, I agree that neither should be there. Just strike that language completely to avoid any confusion one way or the other.
And then with regards to the supervisor, we deleted, I'm not sure of the training Ms. Couch has, and I don't think it's a requirement that the person have professional training. We're currently doing that, but at some point in the future, we may need to have a supervisor that's through the community house that maybe is not professionally trained in substance abuse counseling. I don't think that was a requirement we talked about during the hearing.
Ms. Day, can you remind me of who that person was?
Yes, Leanne Couch is a professional. She works as a substance abuse counselor for the Tootle School District. And she was the person we were able to obtain who was neutral, not with a relationship with either the petitioners or either of the parents, but a person who was willing to supervise for a limited period of time. And that was agreed with court for these first visits. Whether that will continue or not, or whether that will be necessary, I don't know. I agree that she will continue to be the supervisor until something changes. And if we need to bring that back, we can. But I think it's also good to have language in there that says we could agree to another supervisor, but I don't think they should have to have that requirement. If the parent, either parent, is compliant with their treatment, then having a professional substance abuse person chosen is going to be very difficult. That's probably not something that would normally be done. And I would like to not have that kind of pigeonholed for Jessica, because that could potentially prevent the visit from occurring.
Okay. Anyone else?
I concur, Your Honor.
Yes, Your Honor, in the minutes from our last hearing, the only supervisor that we discussed was Leanne Couch. We would like to keep Leanne Couch as the supervisor. We included this language as a way to provide some flexibility. If there is not, I mean, we would of course like to make sure that a supervisor is agreed upon, but if Leanne Couch cannot be the supervisor, we would prefer that someone who is a professional be supervising.
So what I'm
And
going to do it.
I'm sorry, go ahead, Your Honor, I apologize.
So what I'm going to do at this time is go ahead and leave that language out, because it also has shall be chosen and agreed upon by the parties. So maybe there is someone else that everyone can agree upon. And so if the guardians don't agree to it, to the person, then the matter can be brought back.
Right.
Okay, anything else?
Nothing further, Your Honor.
Nothing further.
Nothing further.
All right, with that, did the matter get set for hearing or trial?
It was set for trial, Your Honor, September 30th.
Okay, all right. So while that is pending, is there anything else that we need to address at this time, Ms. Day?
The only thing I would let all the parties know is that mother has entered inpatient treatment. She's expecting to be out the middle of June, and I will send out an email to kind of begin the process of arranging. I'd like to arrange for those visits to start once she has been released from inpatient and entered into intensive outpatient. I expect to have the results of her UAs and evaluations should be coming in early next week, and I will provide those as soon as they do. And I would just let the court know that the father has had his 2 visits since we were last here. Those are going well. Jessica has managed very well with the visits. So I'm looking forward to seeing that continue to progress forward for both the parents.
Okay. Anybody else?
Well, just with regards to the visits, Your Honor, there was a change in the day and the parties agreed to that. I'm just reporting that that change occurred, and everybody agreed to a slight change and it worked out.
Okay, good. All right.
And Your Honor, I agree with the information that Ms. Day provided regarding my client. I had the same information, so nothing to add.
Okay. Ms. Cowden, anything else?
No, Your Honor.
All right. So I think at this point, there's really no reason to set this on for any further review or anything at this point. If mom, is successful and wants to note it back up for something, then she can do so. But otherwise, no need to keep having reviews or anything of that nature.
Thank you, Your Honor.
All right. With that, going to number 3 on the docket. 23-4-00417-08. And this is a request by dad for more time. And also a contempt matter.
Your Honor, I think there's 2 different. The motion to address the visitation is the GAL's motion, and I think contempt is sent for a different date.
Okay. Yeah, I thank you. I actually recalled that after I said that I think it's set for a week or two out. So with that, disregard the contempt matter. Let's just address that one matter. Before I get started, who all do we have here? I see. Okay.
Hannah Cowden for petitioners. And if I may say something before we begin after everyone
That's
has.
fine. Wait, I see Katrina Force, and anyone else on this?
No, Lisa, for Katrina Vorse, Your Honor.
Okay.
Jack Carnahan for father.
Okay. All right, Ms. Cowden, go ahead.
Yes, Your Honor, before we get started, I will note for the court that my withdrawal has been filed. And while I have advised against this for my client, I've been informed by my client that they would like to represent themselves in today's hearing, as opposed to have me speak on their behalf.
Okay. All right, Mr. and Mrs. Force, is that correct? That's your understanding?
That is correct.
All right, you're gonna need to turn your volume up just a bit. I'm not sure what's.
I don't know, I can talk a little louder.
There, that's better. If you talk louder, that works better. Okay. All right, so this is a request by Dad, but I don't see Mr. Anagnostou, and I don't recall.
This is the GAL's motion, Your Honor, not Dad's motion.
Oh, I still don't see Mr. Anagnostou.
He is not present. He is out of the country. He was aware of the hearing and was going to attempt to have somebody represent him, but he indicated no objection to moving forward without him.
Okay, all right. Ms. Day, go ahead.
Thank you, Your Honor. I appreciate it. Sorry for all the confusion back and forth. So this is my motion because of my concerns about the petitioner's continual interference in the visitation with father and refusing to engage in any kind of contact or response to visitation with mother. So in regards to father first, Mr. Vorse, petitioner, unilaterally decided not to have a visit last week based on his own decision in contrary to the order that you had put in place. I reached out to Mr. Vorse and to his attorney, attempted to try to resolve the matter, and was met with just simple refusal. They believe that he believes he does not have to follow the order and that he has the right to protect Jessica, superseding your order and the written orders of the court and father's right to visitation. My contention in this matter is very simply, Jessica has a right to visits with her parents. And my role in this matter is to help protect that right and to support her and make sure that that happens. Jessica's had 3 visits. The visits went very, very well. She's readdressing and rebuilding that bond she has with father. Father is doing an excellent job in entertaining her and engaging with her at her level and in providing and demonstrating appropriate parenting responses. To interrupt the visits unilaterally is not only a violation of the court order, but it is detrimental to Jessica. She has 3 visits. She just is getting into the swing of things, and Mr. Vorse decides to stop the visitation. He indicated in the email he sent he was refusing to do the visit because he was not provided a UA. I have provided all the documentation to his attorney as soon as I can get it. And sometimes there is a delay because it takes time to get that information from the treatment center to myself, get him processed and faxed over to everybody and served with the court. But he has remained in compliance and I've provided proof of that. And when the concern was raised, I've checked on that. When we moved forward and I tried to provide that information, Mr. Vorse just simply refuses. That brings us forward to no visit, and Jessica again is interrupted. Her contact with her parents is interrupted. When this week's visitation came around, again, Mr. Vorse refused to do the visitation under the same grounds. And after some back and forth with him and his attorney, the visit did finally happen on Tuesday. There was some discussion about how that was supposed to happen. And that was made arrangements with Miss Leanne Couch to supervise the visit, but this will be the last time she's able to supervise. She showed up for the visit that was missed from Tootle without any ability to supervise the visit. It didn't happen. So she did make herself available this week, but I believe this will be her last week to supervise the visits. Based on Dad's ability to manage Jessica, the bond that's rebuilding, Jessica's comfortability, and the demonstrated recovery time, I think it's appropriate for the visits to move forward. I think they should move forward monitored at the community house. I think that's perfectly appropriate. Dad has shown levels. But most importantly, Your Honor, I'm asking for you to please provide direct instruction to the petitioners that they do not have the right to supersede your order. Now, I do want to address their response. In the response I received, there was a new allegation that Ms. Couch had indicated she was concerned father was under the influence. And I spoke directly with Ms. Couch about that the day of the missed visits and the day that that declaration came out. So first I'll say that information was never provided or presented before, or it could have been addressed the day of. I believe it's just disingenuous on Mr. Vorse's part by presenting that for this hearing. There was no discussion of that, no report of that by anybody to anyone, including Ms. Couch, who I spoke with after the visitation that she supervised before the missed visit. Mr. Carnahan has remained in compliance. He has not, that I can determine, been actively using anything. All of his UAs have come back clean. He's in treatment. He's going to meetings. He's doing parenting classes, and he's attending all the visits and complying with the court's orders. Only person not complying right now is Mr. Vorse. And I need the court to please secure Jessica's right to visitation with her parents and help move this process forward so that Jessica can hopefully be successfully reunited with her parents. And then my second request is just that you would order some set visitation times for mother. Mother has graduated treatment inpatient. She's provided clean UAs. She's been accepted with the CHESS program, and so she has secure housing. And I provided that information under sealed for your honor to review, as well as to the other parties. And so rather than having to bring another motion, I'm asking that we can do this both at the same time, if you would. And that's all I have.
So, Mr. Esau, anything from you?
Just a couple of things, Your Honor. We would join in the motion to allow visitation with Katrina Vorse, the mother. She has completed treatment. It was it was inpatient treatment, and she graduated, I think, a day early or something of that nature. But she's done a great job. She's provided clean UAs. Previous visitation was for an hour and a half until she got caught up on some missed visitations back in January because of delay that we brought before the court at that time. And then it was previously for an hour. So my client would at least want to have at least an hour every week. I'm not sure where that will take place or who will supervise at this point, but I think that those visitations should restart. If she hasn't made up all the time for the missed visits in January, then I'd ask for an hour and a half until she gets those taken care of. Yeah, that's all I have to offer at this time.
So before I hear from Mr. and Mrs. Vorse, I want to speak to the idea in regard to the request for the mother's visitation. This is, I commend the mother for the work that she's done, and this is not to minimize that. But the problem that I see on these minor guardianships is too much is done without a notice, without filed documents. So I will not be considering it's not properly before the court. And that creates issues of what's actually going on and what's before the court. I understand, Ms. Day, where you're at and your request. At the same time, I would ask that it simply be noted up. Shortened time, you can do a motion for shortened time and get it on next week is fine. But at this point, I would like to see it actually noted up and properly before the court.
Your Honor, I did include that in my motion.
Let me go back and look at your motion then. I thought you had indicated you had not.
No, I did include, I wrapped it up into it because I had gotten notice that she was graduating.
Okay, I misunderstood you then.
I apologize.
Okay, with that, then I'll go ahead and entertain it.
Thank you, Your Honor.
All right, so, Mr. Vorst, I'll hear from you first.
All right,
Okay, I can't hear you hardly at all.
in the effort to be totally transparent, we have spent over $12,000 for all money and alternative fees.
Mr. Vorst, I'm having a really hard time understanding you and hearing you. So
Can you hear me now if I talk like this?
yes, yes.
In the effort to be totally transparent, Carla and I are 65 and 67 years old. We spent over $12,000 and several hundred of clothes and cribs and food and doctor's appointments. So that's why the attorney, we just can't.
Mr. Vorst, every time you look down, you just go into silence or minimal sound.
Okay.
I don't know if the others are having troubles. Maybe it's here, but I'm only hearing a small portion of what you're saying.
Okay, is it better now? Wish I knew
Yes.
where the microphone is on this. Anyway, we spent over $12,000 in attorney fees, and we've also several hundreds of thousands of dollars really on cribs and clothes and everything else. So at 67 and 65, it's just not affordable to keep an attorney on. I will say that concerning why we didn't go to visitation specific days request. So I've been working with Washington State, with Congress on the Keeping Families Bill, the 1227, and then the changes in 6109. Both confirm in Section 102, Paragraph 4, that paramount consideration for the court shall be the health, welfare, and safety of the child. Our history, just to tell you where we're coming from when we decide what we're deciding. Katrina Boyce called us to pick up Jessica last November because of.
Okay, we're gonna have to do something different. You're going in and out. I can't hear you. I don't know if you're just using a computer's sound system or what, but it's not coming through.
I can't hear anything, Your Honor.
Yeah, I think he's still working on it.
Okay.
Okay, is that better?
Yes.
Okay. All right. So I've been working with Washington State Congress on the House Bill 1227, that Keeping Families Bill Together bill, and then recently passed modification 6109, which confirms in Section 102, Paragraph 4, that the paramount consideration for court shall be the health, welfare, and safety of the child. Now, I'll give a little history. Katrina called us on November 6th because the police were there to come pick her up, come pick Jessica up. It was in the pouring down rain, and she was just wearing a diaper. We obtained this 168-page from Peace Health. This is 2 years of medical history for Jessica. In that time, she had 2 broken arms, multiple cases of MRSA, multiple abscesses, and several other medical problems. We've also obtained the criminal records for Jack Carnahan, where over 40 times in the last 11 years, he was arrested or confronted with police on different offenses, 40 times in 11 years. So, on one of those investigations, included pictures that the sheriff took inside of this black plastic wrapped home that Jack called home, with Jessica's clothes and diapers and baby formula next to drugs and drug paraphernalia. They were there investigating the charges of a fentanyl pill being found in her mouth, and the charges of child neglect for Jack Carnahan came out of that. Now, under the advice of Dr. Canada, who has been her primary pediatrician physician since birth, we took Jessica to Progress Center to be tested, and Jack and Katie had been asked this multiple times in those 2 years. We took her, and they found her to be behind in cognitive and communication skills, And because some of her behaviors that were noticed, they referred us to a child trauma specialist, Patricia Anderson. Now, Patricia
Excuse me.
Anderson, her February.
Hold on. Mr. Vorse,
Yes.
Mr. Esau,
Yes, Your Honor, I have to object at this point. I mean, this is not responsive to the motion for visitation with Jack Carnahan. We're getting into testimony about the ultimate facts in this case, and therefore, if we could have him just address the issues of visitation, we all understand why we're here, and we don't need to go into things that have already been established through the documentation in the case. So I'm objecting to any further discussion of the background and ask that the petitioners address the guardian ad litem's motion for visitation.
so Mr. Vorse, I would just ask that you bring it back. I understand the nature of why it's here. I understand the allegations and what you've said and the evidence that you're talking about. I would just ask that I understand all that. So let's narrow it down to what it is that Ms. Day is requesting at this time. What is your concern now?
Okay, according to the order, even the last order, the guardians are responsible for the physical and mental health of the minor. And so regarding this, when I'm talking about what things that Dr. Canada said, or that now trauma specialist Ms. Anderson said, this goes towards why we say that this is against the order, because this is one of the aspects that we're responsible for her mental health. In her February 13th report, she said there are reported behaviors of our concern that this child has experienced trauma. I hope that this will be taken into consideration and determining next steps for living arrangement for Jessica. She also advised me while I was there against having any visits with parents at this time in her life. Maybe later, but not now. I did text from her office during that visit. I texted the Guardian Atlanta team today this information. On May 16th, the court ordered visitation. That's when you actually ordered visitation. And in this order, it says the conditions for visitation shall have visitation providing a clean UA to his attorney or petitioner, with the UA to be conducted regularly, allow review for continued compliance as will be required for visits to continue. If the results of the UA show that use of any substance not prescribed legally by a doctor show up as positive, including marijuana levels rising upwards at some point, at any point, levels above 5.1 of May 15th, although that was collected on May 8th, visitation shall not continue. It also states in there that the in-house will serve as the supervisor. During the last hearing, Clerk Agnoster and Guardian Litem both said during that hearing that Jack Carnahan goes to 2 different treatments and he gets a UA every week, so there's no need for hardship or providing another one. They would forward as soon as they get them. Now, after 5 months of not hearing anything from Jack Carnahan, Tina Day submitted to us an email of UAs for Jack Carnahan's most every week in April showed methamphetamine use. And so we also received for weeks 429, 52, and 58. After that, we received just a drug screen that showed no levels at all. And lastly, a report from Core Health on June 12th that simply states month of May compliance with no UA. Now, I called Core Health SUD supervisor, Ashley Bowers, and I said, I just asked, do you do random or do you do regular UA? And she said, no, we do not. It is totally random. So now we're left to say that this self-confessed said this, and it's that motion filed that he's been a drug addict most of his adult life. And so I don't know if he's coming clean or not. In fact, on April 17th, he tested positive for fentanyl. Now, I am concerned that there might be fentanyl on his clothes when he picks up this little girl and holds him. So on May 21st, the first visit we had with Guardian ad litem, she was overheard telling Jessica to go give, referring to Jack Carnahan, a hug goodbye. Now, when there was strong evidence that she was abused sexually underneath the care of Katrina and Jack Carnahan. On May 29th, visitation was without the agreed supervisor and only the guardian ad litem, which is in direct violation of your order as well. After the June 4th visit, we asked the court appointed Leanne Couch how Jack Carnahan looked, since we have not seen a UA since May 8th, almost a month. She said his eyes looked funny and that she would be contacting the GAL King of Day. On my follow-up call with this 13-year drug counselor, she was told by Tina Day that the medication he is on makes his eyes look like that. As of today, the GAL has not asked us, the guardians of over 7+ months now, how Jessica was after any of the visits, which is reasonable response by this, it's another RCW, that says that to determine the minor's best interest, to the extent known, or that can be reasonably ascertained by the guardian. On May 16th, at court hearing, also the guardian has the power over healthcare decisions, including mental health. Since these visitations have begun, we have noticed these changes. She was mostly potty trained, even going poop on the toilet, and now she just cries when she's sitting there. She was talking so much better, and even singing her ABCs, her whole ABCs. And now she's back to often mumbling, grunting, pointing instead of talking clearly. This is how she was when we got her back in November. She was going to sleep every night, just laying down and going to sleep. And now she mostly cries when we lay her down and wakes up during the nighttime screaming, standing up in the back of her crib, screaming, no, no. And a lot of times she wakes up. Now, in fact, last Tuesday, we took her to visitation, and that night, which she normally goes to bed at 8:30, and she laid there awake, crying and sobbing, we're in the room until 11:30 at night. And she woke up many times during the night, and a lot of times just saying, Nana, are you still there? She normally loves daycare. And now they have called us twice just this last week to come pick her up because she doesn't participate. She just lays there by herself. I'm not saying this happens all the time. This has been happening since the visitation. RCW 11-130-230 says, does hold a minor guardian accountable to act in the child's best interest, including 2A says, including physical and mental health. I just have a brief summary and I'm done here. We have known Jack Carnahan for over 10 years and Katrina for a whole life. They have been heavy drug users for the last several years, resulting in many criminal activities and many medical problems for Jessica. The court ordered regular UAs, which were provided beginning the end of March until May 8th for a total of 7 in a row, and then they just stopped. All of April's tests were positive for methamphetamine through April 17th, and even tested positive on April 17th. On that day as well. Now, no explanation was given to us why they were stopped, or even though the court ordered that they were required them, and the GL and defense attorney told this court that they would be being done every week and would be provided. Additionally, when the trained supervisor told GL about unusual symptoms, she dismissed her experience observation. According to the original court order on 11/4 and continuing with the president, we guardians by order are responsible to do what's best for Jessica, including mental health. Jessica's physician from birth repeatedly reported how poorly Jessica was doing, noting failure to thrive in almost every report, and how well Jessica is doing under our care. Additionally, trauma expert said in her report, Jessica will thrive on routine and structure as well as appropriate expectations from nurturing adults. I might add that Jessica has not had one broken arm, not one abscess, and not one MRSA since we've had it. No one, including the GAL, has asked us about how Jessica was handling the visitation. Simply stated, I'll just tell you, Jessica has regressed and is an emotional mess most of the time. This was voluntarily reported to the GAL, We dismissed our experience and demanded immediate compliance with visitation. That's all I have.
So, Mrs. Force, you are also a petitioner. Anything you wanted to say?
That is all going on. And over the last month, she has progressed so much that she usually just yells at us. She mumbles like she did when we first got her. And she's afraid she's going to be left. Like I said, she'll wake up in the middle of the night to see if we're still there with her. And I am concerned about whether or not they're on drugs when they come, because we haven't seen anything. But when she calls, well, over the last 4 weeks, there's been those visitations, and every night it's worse, every night. And it's hard to watch that movie when you're afraid like that.
Ms. Day?
Yes, Your Honor. It was very hard for me to hear. It sounded like mostly mumbling, so I will do my best to respond and keep it as brief as possible. I first want to say that I appreciate all the work that the Vorses have done, but they have, by their own choosing, spent the money and taken the steps to help Jessica, and I appreciate that. And I'm sure the parents do as well. But I want to be clear about a couple of things. I have read through those medical records. I've spoke with Progress Center, read their records. I've spoke at length with Tricia Anderson, including this week. And there is no evidence to suggest that Jessica was sexually abused. And I want that to be clear. There is no evidence of that. The only information that any of the providers have comes directly from the petitioners. Yes, I believe Jessica has suffered trauma. She's been in less than stellar conditions while she was living with her parents. She was removed from her parents, and she is very young and has a difficult time, as any toddler would, understanding why she was taken from her primary caregivers in her primary living arrangement to a totally different location, and then not had any contact with her parents for more than 6 months. I think that that's important. And I think the court is very well aware that children often go through difficult emotions, including regression and acting out, when they restart visits or begin the transition home or transition all the way home. That is not uncommon. And that is not indicative that something terrible is happening to this beautiful young girl. I've seen her at visits. I have sat through those visits, and she is articulate. She is able to advocate for herself. She speaks very well. She behaves. She plays. She acts like any other toddler that I have ever seen when I see her with her father. I have also seen her with the petitioners when I was there doing the home visit, and with Progress Center there. And she is very much making great progress. She is no longer needing services from Progress Center. She's no longer needing counseling from Miss Anderson. And I think it's important for the court to understand this child has a legal right to her parents. If they can maintain their recovery and move forward, they have a right to their child, and their child has a right to their parents. And I think that that's most important. Jessica has a right to a relationship with her parents, and these are her parents. Nothing that I see going on currently would tell me that there's any inherent risk to Jessica than there has ever been to any child who have parents who suffer from addiction. They suffer from addiction, and they're finally taking those steps, and I commend them for it. I don't think we're in a place to rush to judgment and return this child, but I do think that we have to make it very clear that Jessica's rights have to be the most important. Her rights, her needs, and her ability to develop those relationships unhampered by anybody. She has a right to that. I, again, just ask the court to order the visits to occur, that the petitioners not intervene in those visits and violate the court order, and that the court order visits for mother as well. I've attempted to work that out off the docket with the petitioners and their attorney to no avail. There's simply, outside of your honor giving them clear instructions, there's simply no way to move this case forward. And I appreciate your assistance with that.
So going back and looking at the order extending filed on June 14, 24, there is an immediate order that says mother may have supervised visitation after enrolling in inpatient treatment as directed by the Department of Corrections and upon providing a clean urinalysis to counsel for petitioners prior to the visitation taking place within 24 hours and subject to any limitations imposed by the DOC and or the inpatient treatment facility into which mother enters by order of court in relation to her criminal matters. Supervised visits are to be no more than once a week, visits for 1 hour per week in a public location. Guardian ad litem Christina Day should be present at least the first visit and may be present thereafter at her direction. Counsel for mother will provide documentation to counsel for petitioners showing proof of mother's enrollment, participation, and treatment. And then Jack Carnahan acknowledged his father by the state of Washington shall have supervised visitation upon providing a clean UA to his attorney for forwarding to the attorney for petitioners with the UA to be conducted regularly to allow review for continued compliance as will be required for visits to continue. If the results of the UA show that use of any substance not prescribed legally by a doctor show up as positive, including if marijuana levels rise upward at any point above the levels of 5 or 5.1524, visitation shall not continue. Supervised visits will be once a week for 2 hours per visit in a public location. Leanne Couch will serve as a supervisor. If Leanne Couch is unable or unwilling to serve as supervisor, another supervisor shall be chosen and agreed upon by the parties. Guardian ad litem Christina Day should be present for at least the first visit and may be present thereafter at her discretion. Supervised visitation is conditional upon father's continued enrollment in substance abuse treatment. I read that to make sure the record is clear and everybody understands what it is that I ruled. So I want to ask, Mr. Forrest, if you're representing yourself, you have got to get a system that can be heard, because most of what I heard from you was garbled. So I could not understand what you were saying for the most part. I tried to figure it out based on the few words that I could understand. So that's one thing that you're going to have to do, is get a system that works. If I heard you correctly, I had the idea you were concerned about the UAs. I'm not sure if that's what you had indicated. And I understand I understand about the child and all that. I heard that part. So let me just follow up. Unfortunately, we don't have Mr. Anagnostou, because I want to know whether or not council received clean UAs. Mr. Esau?
Yes, I did, Your Honor. I did not provide them to counsel, Ms. Cowden, because Ms. Day was doing that. And so I didn't want to duplicate efforts at this time. So, but yeah, so I failed to do so, but I thought I had a good reason because they were already being provided by Ms. Day.
Okay. So Ms. Day, can you clarify as to the times of visitations were going on? Were they provided within the 24 hours?
They were provided within 24 hours of my receipt from the either treatment center, whichever treatment center, and I have to request those records every week. They don't just send them out automatically, and I provided them. The challenge with father's treatment is that they have to be done every week. With mother's, I've been able to get all of that at one time. She has completed treatment, and I did file that, as well as the clean UA.
Oh. So what I'm trying to clarify without pulling up records and looking into it is just looking at a clean UA to his attorney for forwarding to the attorney with the UA to be conducted regularly to allow review for continued compliance. So it sounds like that's what's occurred.
Your Honor.
That has occurred, Your Honor. The challenge has been that the UAs done by Community House are the traditional dipstick. Unless they show positive, they don't get sent back out. So that's why I had them provide a letter to indicate that, and I spoke with them directly. The UAs that are done by the treatment center, which are random, not done every week, they are random, those are provided upon receipt, and I request those every week.
So, Your Honor, can you hear me now?
I can.
I think the problem was I run off my laptop, but I had it closed. So we had received 7 UAs in a row from Miss Day from the end of March until the 8th of of May was the last one collected, and then they just stopped. The only thing we got after that was a drug screen, which showed no levels, and something from the Core Health that just said May compliant. So, like I said, the SUD supervisory court says that they are only, like Ms. Day just said, that they are only random. So we don't know when the last time he was actually tested. The last UA that we saw any levels was from May 8th. And unless she's got something different, the only thing I have all of them right here. And
Okay,
the
well,
last
I don't,
one,
okay, I'm gonna just stop you right there. One thing, I have a limited docket here. I can't go through these things in detail, I've been struggling with hearing. I've been struggling with everything else going on. And unfortunately, Ms. Cowden, I don't know if you can at least respond to this. Have you received the UAs?
There's been inconsistency in the timeline in which we've received them. It hasn't been weekly. I've forwarded to my client everything I have received.
Huh.
And as I indicated, Your Honor, the levels don't get run if the UA is clean. So if they do the dipstick and it's clean, they don't send it to the lab unless it shows positive. So that's why there are no more levels being provided, because there's not been a positive UA or any reason to do the levels by the provider. I can't instruct the provider to run the levels at my request. I can only provide the documentation the treatment center provides me.
And if I may, Your Honor, that was not communicated to us.
and the order was for a clean UA.
Not every week though, it was my understanding.
Okay. So here's what I'm going to do. One, I'm not changing anything yet. I've ruled what I've ruled, and I want it specifically followed. And if I need to do another order that shows, I understand where Mr. and Mrs. Force are at in regard to their concern, whether it rises to contempt or not, I don't know. But at the same time, if they're not receiving the UAs, what I don't have in here, let's see, clean UA. So if at the community house, Mr. Carnahan, I can't address you. Your attorney's not here. I'm sorry. He didn't have anybody else appear, and I don't feel like any of this. So at this point, I don't feel comfortable, one, that Mr. and Mrs. Force haven't heard a good part of what they've had to say. Secondly, I don't feel comfortable that Mr. Carnahan is essentially unrepresented, even though he's represented. And I'm not going to specifically, I can't talk to you, Mr. Carnahan. I apologize that Mr. Anagnostou didn't get, you know, I mean, that's on him. I don't know what to do. There's nothing I can do. And that Ms. Cowden, who has been representing, is suddenly not representing, and I'm hearing from Mr. and Mrs. Force. I want this cleaned up as far as who's doing what and having the attorneys present. This is important. And I've already ruled. I understand, Ms. Day, you were asking for additional, and that my concern at this point is in regard to this other supervisor. I want a supervisor. I'm not completely comfortable at this point that we just go without a supervisor yet. So if it can't be Ms. Couch as indicated, then it needs to be another supervisor. At the same time, Mr. and Mrs. Force, I expect you to follow. The parents have a right. I get your concerns. I agree with Ms. Day that the child is going to go through issues. It's going to be a part of reunification and seeing the parents. It's going to be, I'm not going to tell you that it's going to be a simple process, but this idea of hanging your hat on the idea that you're looking out for mental health and therefore not have visitation. I have a court order. I expect you to follow that court order and do exactly what I talked about. I expect everybody else to do exactly what I talked about and what I ordered. So I'm setting this, when is Mr. Anagnostou back?
I believe it's the week of the contempt hearing. I don't have that date in front of me.
Okay, so I'm not going to make any changes today. I want better system, Mr. Boris. I did hear you after you did whatever you did with the laptop. And Mr. Carnahan, you need to reach out to Mr. Anagnostou's office. If he can't be here on that date, then they need to have somebody else present. Ms. Cowden, I'm assuming from the confusion or what's going on here is that you're withdrawing from the case. Is that my understanding?
That is correct.
Okay. So bottom line, I expect everyone to follow, and you're going to have to work out another supervisor, but that's not going to be a basis not to have the parents see their child. They have a right under the law to see their child. They're doing what they've been ordered to do. So I expect you to follow through. And if they provide the UAs as required, then I expect you to follow through with the visitation.
Your Honor, can you please clarify the UAs? Do you want them every week? Do they need to pay for them? Because that's where I think the confusion is. The petitioners expect clean UAs every week before visitation, and I simply cannot provide that from the providers who are doing the UAs. And that was not your order. So if that's what you're changing, I need to understand that.
Well, I can tell you that's what was submitted that everybody has signed off on.
That are supposed to be there every week, because this was specifically addressed at that hearing, not every week.
However, the attorney's UN.
Stop, just stop. With the UA to be conducted regularly to allow review for continued compliances will be required for visits to continue if the results of the UA show that use. So I'm not showing that it's every week. The one on for mom, it was a clean UA to counsel for petitioners prior to visitation taking place within 24 hours and subject to any limitations imposed by DOC. So I don't know how often DOC is doing their UAs. Mr. Esau, do you know?
I believe it's on, I would have to defer to my client, but I believe it's only when she goes in to meet with her probation counselor. She's raising her hand to speak.
So I'm not going to do this. I am now at 11:42 and I have all these other people that have been waiting. I expect the UAs to be weekly. I don't expect them within 24 hours at this time. They're supervised visits. And I expect the Borses to follow through. When you're provided that UA, I expect you to follow through with the visitation. If you can't agree on a supervised visitation, I'm going to have Ms. Day make the decision because I want that visitation to continue.
Decided I'm on the form.
All right.
Okay.
That's it for that matter.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
It'll be over on the next.
The contempt hearing on the Tuesday. Okay.
Oh, the contempt matter got set on in front of Judge Basher. So what date is that?
July 9th.
Okay. All right. So we're going to set it over to the 11th, the contempt. All right. That's it.
Thank you, Your Honor.
Thank you, Your Honor.
All right, that brings me to guardianship of Jessica Forrest, cause number 23-4000417-08.
Morning, Your Honor. Donald Lisa on behalf of Katrina Vorst, the mother.
Okay.
Kurt Anagnostou on behalf of Jack Carnahan, the father.
Tina Day, guardian ad litem.
Mike and Carla Vorst, guardian.
Casey Looney on behalf of the state as to child support owner.
Okay. All right, so this matter comes on in part because the last time we were here, there were technical issues. There were issues about who was going to be doing what. And overall, and then I found out apparently there were several documents that I had not seen before going on the bench. So I did not have the opportunity to review everything prior to actually hearing argument on the motions because of that, that the court found it only appropriate to have it come back and properly heard. That said, I did want to inquire, hold on just a second. On June 21, there's a petition to terminate that was filed by Mr. Force. And I don't know if, one, it was not signed off by the other guardian, which is Carla Force. So I don't know. Let me hear from the Forces first about that matter. I think it's set on for next Tuesday, but I just need to find out if that's the intent, is to terminate this guardianship.
As long as there is visitation, it is, because she is a total emotional wreck. Even though the doctors have said, her doctor and the psychologist have said, visitation is not okay for this baby at this time. Sometime, but not now. And for some reason, the guardian at Lidum just ignores that. We have a screaming baby. She's potty trained. She no longer goes to the bathroom anymore. She screams, she spits food. She has not been like that in 7 months. It's very, very hard. She's never once mentioned mom or dad. Never once. But something is going on with that baby.
So, one, I can tell you that the petition is only signed by Mr. Force. So if it's the intent of both of you to terminate the guardianship, which is your right, then Mr. Force can't act on your behalf, just so you understand that.
Yes.
So it needs to be signed off by both parties.
As long as it's visitations, we just can't handle it. I mean, this family.
I don't want to get into the whole thing. I'm just trying to find out if you're terminating. The whole point of minor guardianship is the intent to reunite a child. So I'm not going to tell you that whether now or in the future or whatever it may be, I don't know, is that the whole point is to reunite the child with the parents. So I need to understand that.
I understand that. I just worry about the relapses and the possible fact that Katie's going to be going to prison for federal fraud. She applied for.
I'm just going to stop you there. I don't want to get into all of this. I just wanted to clarify whether or not you intend to terminate. And if you do, one, it only signed off by Michael Force. It's not signed off by Carla Force. So just to identify that one issue that I saw, but I didn't know if others were familiar with that motion being filed and on for Tuesday, because whether service was made of that or not, I couldn't tell.
Yes.
I question whether or not we go forward today or whether or not we wait and see if it's terminated.
I mean, it can be terminated now. It's very hard to handle a baby that is out of control.
Your Honor, if I may.
Go ahead.
So my motion was to increase visits because my client was getting very limited visits over. He lives at the community house, drug-free environment, and he's getting very limited once-a-week visits. And so we brought a motion to increase his residential time, and we complained about what happened on some of the past visits. But that aside, if the Vorses are going to terminate, this is a golden opportunity to transition Jessica into my client's residence. There was a parentage action in Cowlitz County, and if the court wants that number, I can provide that to you. My client under that parentage action is the residential parent of the child, of Jessica. And so she would be returned to his primary care, and then Katrina, the mother, can bring whatever action she wants in that action to set up visitation. Mr. Esau, of course, is representing her, but going forward today, we have a motion to terminate next week. This is an opportunity to transition Jessica back into my client's residence at the community house.
Counsel, Mr. Esau.
Thank you, Your Honor. I concur with Mr. Anagnostou, and I'm not sure about the parenting plan situation because I haven't seen that yet. But I would, certainly not object if I don't have a basis. Anyway, the visitations with my client have been going well since she's been back from treatment, inpatient treatment. I talked to Mr. Vorse about this case a couple of weeks ago, I think, before the holiday, and he indicated he was going to terminate. But then the paperwork that I received by email, which was okay with me, I would accept that, indicated that they were asking to resign as the temporary emergency guardianship. So I'm not sure what they're asking for. Their words say that they want termination because they can't handle the baby. I understand, but their written word says they just want to resign, and I'm not sure if it's their intent for somebody else to take their place and somebody else to be appointed as guardian, or to just take it back to the parents. My client, I haven't had a chance to talk to her about this issue today because I knew we were going to be on for next Tuesday. But if I had to guess, I would say that she'd probably want termination and custody of, well, apparently there's an order saying the parenting plan says that it goes to Jack. But yeah, they could work that out later. But yeah, that's what I think my client's position. My client is raising her hand. Apparently she would like to add some information. It's probably information I don't have yet.
So I would ask Ms. Forrest, you have an attorney, you need to communicate with your attorney somehow. So here's where I look at these. When I've terminated guardianships before, I don't have any authority over the parents as far as who gets that child after guardianship. There's no active, once it's terminated, it reverts back to whatever case, our custody case, and it's up to the parents to determine or pursue that if that's what they are going to do. But as far as the idea that I'm going to then have the child go with Katrina Force, I'm not aware of anything within the statute, and I'll go back and look at the statute to see if there's anything upon termination. But and maybe it's there and maybe they did put it in there, but if there's a parenting plan that's in place at this point, then to me that would be the overseeing order that would be there. But I'll go back and look at the as far as what happens between the parents.
Right. If I could clarify, Your Honor. So there was a parentage action. I have the number here, but there isn't a parenting plan. It says the child will live with, and then it names my client, and then it indicates that a parenting plan was going to be filed. But as far as I know, one wasn't. So it's just the base order that says my client is the custodian of the child, and an indication there would be a parenting plan, but as far as I know, there wasn't.
Your Honor.
Go ahead.
So the original emergency guardianship was taking Jessica from Katrina, and that's how it was actually read, because of her drug addiction. In fact, that's how the order I asked you to sign was, because of her drug addiction, and she was going to jail. So now that both of those were complete, as far as the emergency guardianship order that was originally granted, those were the reasons.
Okay. All right, so right now there is visitation in place. I know, Mr. Anagnosti, you were asking for expanded, but it seems like if it's going to move forward on the termination, then it seems rather doesn't make a lot of sense to work on a visitation plan in a case that's going to be terminated.
Well, if it's going to be terminated next week, we just want the child transitioned to my client at some point. I mean, is it going to be immediately following the hearing then? I mean, that's, I guess, would be good. It just seems between now and then, we have this opportunity to set up some kind of transition.
So that's where I want.
Your Honor, this is Tina Day.
Yeah, go ahead.
Thank you, Your Honor. It is my understanding from what the divorces have said in the petition to terminate the minor guardianship and their statements today that they do want to terminate the guardianship. I would propose to the court that a transition makes the most sense. We're talking about a very young child. She has had 14 hours of visits with her father, and she has had 3 hours of visits with her mother. The parents work together very well, and I don't think that there's any reason that they can't resolve a visitation plan between the two of them moving forward. But I think to leave this child in a situation where this is all going to just be dropped next week is a little bit concerning. I again, though, the court has no control over the petitioners. If they wish to step out, then this child needs to be returned to her parents. And it would be my recommendation today that would be to Jack, because he's had the most time clean and sober, the most time with the child, and Jack and Katrina can work out how they want to resolve their visitation issues between the two of them. They both have stable housing at this time. They both have housing that accommodates the child. They both have good communication with each other and are able to co-parent this child. And I think that is the appropriate decision if the petitioners want out. This child needs some stability and consistency and does not be in a situation where she is subjected to the kind of conflict that's going on currently.
So here's the first thing that needs to get done is the petition to terminate needs to be amended or needs a new amendment that includes the signatures of both parties, both Mr. and Mrs. Force, because the one that was filed is only signed off by Michael Vorse. So procedurally, that's the first thing that needs to happen. Second, if there's a parenting plan that kicks in and that parenting plan needs to get filed or something to show who has primary care. From what Mr. Anagnosti says, it's his client, and I don't have doubts of what he says. I just think a record needs to be made, and then a transition plan, the Vorses returning the child to the father, if that's the case. And then it's between the parents as to what happens from there under their parentage case.
So, Your Honor, do we just need to go to the courthouse and have her sign that order?
No, because it's already been filed. You'll have to print out a new one and just both sign it. You can put the exact same information, just need to both sign it.
Okay.
I'm looking at least a copy that I have. It has Carla Vorse's signature on it. It's basically the very last page, the page before that. So they signed on separate pages.
Oh, let me look again. Maybe I didn't look far. You're right, Mr. Anagnosti. I did not look.
I hadn't either.
far enough. I apologize. Yes, it is correct, Mr. Force. I didn't go down far enough. I just went to what I thought was the last page.
Right, me too.
So then, Your Honor, can we have a ruling from you on how to transition between now and next week?
Okay. So I just need to confirm, I don't want all the side information. Michael Force, are you wanting to terminate?
Yes.
Carla Force, are you wanting to terminate?
Yes.
Okay.
I would like to say that if there is a problem and there is a relapse, we are here for that baby again. Katie is our niece. We care about these people.
Thank you. So, Mr. Anagnostou, is there a way that you can scan real quick or tell me the cause number?
Oh, sure. 24-3-00158-08. And that's the public record following the confidential paternity part of the action.
Okay. I'm going to pull that up here.
We could take her to where Katie is today, this afternoon, if you wanted.
Okay, just a second. I just want to confirm everything before I make any kind of. Mr. Anagnostou, is there another number? Because this is just the.
The order granting summary judgment has the most recent order.
Okay.
And parents are supposed to move that case forward for future orders.
So I just have a summary judgment order for parentage as the final order. I don't have a parenting plan in that cause number that you gave me.
Correct. And so it's paragraph 8.
And let me look here.
Which indicates that they in the future can file a parenting plan or residential schedule. And then below it, the box checked is that, but I don't think one was ever filed of.
It's not, at least not in this case, if they have another case somewhere.
So basically placement under this order is with my client.
What did you say?
Said it's not in the parentage action. Once we convert it to the 3 case, then the parents are supposed to move it forward for final.
Yeah. Yeah, the parenting plan wouldn't be in this.
Right.
So that's what I know at this point. Very limited information. And so, Mr. Issa, are you good with that? I mean, that's the order that I have at this point. Are you good that the child goes to dad?
Well, I don't know because I haven't asked my client.
Okay.
So I think, I mean, obviously the order says that it goes to dad. So I don't have a position at this point until I talk to my client.
Okay. Well, again, I'm limited to what's ordered at this point since I don't have any authority over the 2 other than, especially when I have a court order that tells me that. So with that in mind, Ms. Day, anything that you can tell me, you kind of did, but just go ahead to confirm any concerns at this point in regard to the child going to dad's?
I don't have any significant concerns with the child being placed with the father or the mother. They both have demonstrated their ability, although they were late to participate. They have both been very consistent since then. father has the substantial time, and my understanding and my reading of that order is that he is the residential parent. My understanding from contact with both the parents is they are working together and can co-parent. So I'm certain that they will come up with a plan that works for both of them and for Jessica. I think it's appropriate to dismiss the action and allow the parents to be the parents.
So here's what I'm going to do. First off, anything else from anyone?
Nothing further.
So what I'm going to do is I'm going to sign off on an order terminating. And then I will go ahead and identify that the child will be, I don't know, Mr. Vorse, you said something about transporting or bringing. I wasn't quite sure what you said.
Well, I just said we could bring her things and do it tonight if you want.
Okay. Mr. Anagnostou, is there a time that works for your client?
Any time that is convenient for the horses.
Okay, Mr. Vorse, what's a good time?
Well, we pick her up from, well, we can pick her up from daycare anytime after 2, actually, so. And in fact, it would probably be good that they come over and sign up as the people to pick her up and to drop her off to use daycare.
They have to
I know. But we can do that where we can sign them on as the,
they have to reapply.
yeah, but we can sign you right now to be able to pick up from daycare. So if you want to meet me there at 3 o'clock this afternoon or something, that would be.
3 p.m. I'm sorry, which daycare?
It's over at We Care Daycare. It's on Catlin.
Right.
That they will have to reapply for that grant.
Yeah.
All right. All right. I just want to confirm anything further from you, Ms. Looney, at this point.
No, Your Honor, with the child returned to the parents, there's no interest in child support from the state.
Okay. All right. So we'll go ahead and I'll sign an order terminating, placing the child with the father, and exchange 3 p.m. at the We Care at Catlin. And that would strike the hearing from next Tuesday. So with that, is there anything else that anyone can think of at the moment?
We're going to strike the trial date also from September 30th, right?
Correct. That will happen. Correct.
And the other motions for the contempt and the extended hearing are gone as well.
Yeah, I'll just, counsel, I'm just going to strike those. The matter is going to be dismissed, or terminated. So nothing further on those. I just want to encourage the parents that this child needs clean and sober parents. They need parents that are willing and able to parent this child in a healthy and good way. And, you know, when we have litigation that goes on, lots of emotions can happen. And with lots of emotions happening, I ask that you look to move forward and look to the best interests of this child and see that she has the happy, healthy life that she needs. Okay. All right. Anything else?
No, Your Honor. Thank you.
All right. That concludes this matter.
It came as a bit of a shock to me that the grandparents decided to terminate the guardianship so suddenly. That was the last hearing in the guardianship portion of the case, but they're still going to need a parenting plan.
Katrina Vorse and Jack Carnahan, 243158-08. Looks like both parties are present. Give you a moment to get settled. Okay. Okay, we have, I'm assuming that you're Katrina Vorse. Okay, very good. Welcome to you. And I'm assuming that you're Jack Carnahan.
Yes.
Okay, welcome to you, sir. All right, we're here on Ms. Vorse's motion for restraining order. Give you a moment, sorry. I wasn't sure if you're gonna stand or sit. Looks like you're gonna sit.
Sitting.
Perfect, good. All right, so we're here on Ms. Vorse's motion for a restraining order. It looks like there was a temporary order that was issued on July 18th, 2024. And that was, let me just pull that up. Let's see, that was issued on, like I said, on July 18th, and that was by Judge Hahn. And so, and they set it for a hearing date for today. And Mr. Carnahan, did you receive a copy of that temporary restraining order?
I got 4 pages just stating that she had filed for
Okay.
it.
And did it tell you the date to come to court?
Yes, it did.
Okay, and so that's today, August 7th. And and it looks like there's a child that's, is it Justin?
Jessica.
I have
Jessica. Okay, I don't disagree with you on that one. It was okay, so it's Jessica who's 2. All right. And then, so Ms. Vorse, just checking with you, are you still interested in that temporary order becoming a permanent order?
Okay, I'm just gonna kind of explain because I feel that my child got put in danger when he lost communication and took her up to a drug house and didn't communicate, which is why the restraining order was granted. I want him to see our daughter. She loves him, she asked, but I do not want her to be up at that house. I do not want her to be in the presence of drugs, and I want him to be in compliance with his SUD treatment,
Okay,
which is in the parenting plan. I just have to figure out how to serve him.
okay. And then, Mr. Carnahan, what's your position related to that temporary order becoming a more permanent order? Are you agreeing with it or objecting to it?
Oh, I object to it.
Okay.
Definitely object to it.
Oftentimes, so what I know about this case is that there was a motion filed by Ms. Vorse. It outlines her concerns. Did you receive a copy of that document?
No, I did not.
So it's a document, it says, motion for immediate restraining order. You didn't get that, you just got a copy of the actual order.
Yeah.
Okay, all right. So in that motion, Ms. Vorse outlines some concerns that she has related to the issues in your child. And it's about a page and a quarter where she kind of describes that in single spaced lines. So generally, I think what I'd like to do in these cases is that what we know is that Ms. Vorse has a temporary order that's allowing a restraint upon Mr. Carnahan and visits with the child. And I know what your concerns are. You know what your concerns are. Mr. Carnahan doesn't know what your concerns are, and he doesn't. Yeah, I think he needs to have an opportunity to read what your concerns are and then have his response to that. And so I know what your side of the story is. And generally what we do in these types of cases that we generally continue it roughly for 2 weeks. The temporary order that was issued continues for that 2-week period. Then you would serve a copy to Mr. Carnahan. Mr. Carnahan would know what you're saying, and then you can write a response, what your feelings and thoughts are about the situation, submit it to the court, and send a copy to Ms. Vorse. So that's what I'm inclined to do, and I'll hear if any party has any concerns with that proposal.
The last known address I have for him is up the road, and that's not a safe place for me to go. And so how do I go about having him served?
Well, there's a couple different ways you can do it.
Because I don't even know if that's his address anymore.
Yeah. As far as, is there an address, Mr. Carnahan, that would?
No, that's a good address.
Okay, so you can be served there?
Yeah.
Okay, and then if since Ms. Vorse, anytime parties aren't allowed to serve other
Right.
parties, so you have to have a third party do the service, and that can be accomplished through law enforcement or through a third party.
Okay, I can have a third party serve him as long as I ensure that they're not going to be in harm serving him paperwork there.
Yeah, a third party can serve the paperwork, and obviously that if parties have concerns, they can contact law enforcement about any concerns related to that. So that's kind of where we're at. Mr. Carnahan, do you have any questions about kind of the next steps? The next steps will be one would be, I don't know, do you have a copy of your pleadings?
I have the copy of the page and a quarter that I wrote explaining my, you know what I mean? I have that copy because I typed it up.
Okay.
And actually, no, that's a lie. I do have copies of everything I filed with the courts to have him served. I just wasn't sure about how to go about it.
If you have if you know, not. So
can I do certified mail?
It has to be in person.
Okay. I can have somebody drive it.
So if you have that information, I don't know, Mr. Carnahan, are you in a position to receive that today, and then you could read it and get started on your response?
Yeah.
I don't have a way up there, but I do have it at, he knows where I'm located at. I can have a third party give it to him there.
Okay. I was thinking that you had it here today.
I do not have it with me now. I have it in my room now.
Okay. All right. So you all can work on the service issue to make sure that you get your information to Mr. Carnahan, and then Mr. Carnahan, once you get that information, then you'll need to make sure you send a copy to Ms. Vorse. And it has to be a third party, can't be yourself. And generally you can use mail.
You are speaking of my response, right?
I am.
Okay.
I am. So let me just take a moment to reissue that temporary order until we come back on the 21st, where we'll have everybody's information before me, and I'll have read that so I know what everybody's thinking.
Well, I have gotten his response by the 21st, if he writes one.
Yeah, there's some local rules. If you want to look at, if you go to the Cowlitz County Superior Court website, there's a local rule. There's a series of blue boxes. One of them says rules, RULES. Click on that and then look for rule number 88. That'll tell you the general timeframes as far as responses of when each party has to file their respective declarations. So let me take a moment just to reissue that order and set the new date. And just confirming that you're both available on August 21st at 9 a.m., Mr. Carnahan?
Yeah, I will be.
Yes.
Okay.
I have one other question, if I'm allowed.
Sure. Bear with me one moment. Let me finish this, and I'll hear from you.
Yeah.
All right. So let me just review this, and I'll hear from you. So this is an extension of the immediate restraining order and hearing notice. So what it says is that this order extends the immediate restraining order. That's that 4-page document that you had that was issued on July 18th, and the court is going to reset the matter to hear from both parties on August 21st at 9 a.m. in this courtroom. There's no need to serve a copy of this document on Mr. Carnahan because he's hearing about it. And if you want to come up and take a look at it and read through it, I'm fine with that too.
I have no problem.
Okay. And so then we'll see everybody on the 21st. Ms. Vorse?
Yes, I was in the process of filing for the appointment of a guardian ad litem. Can I file that and have that addressed at the same time at the next court date?
Potentially, you'll have to take a look at the timeframes as far as service and the like. That potentially it could be heard on that date if it fits within the timeframes.
Okay.
And you can check on that local rule 88.
Okay. Thank you.
Okay. Any final questions, issues? Okay. Thanks. Next, I have Katrina Vorse and Jack Carnahan, cause number 24-3-15808. Looks like Ms. Vorse is coming forward, and I'll ask if Jack Carnahan is on the line. Jack Carnahan. All right, Mr. Carnahan, if you're on the Zoom call, please make sure you're unmuted and state your name, Jack Carnahan. I'm looking on the participant list and I don't see Jack Carnahan listed. So let's see. Ms. Vorse, have you had any communication with Mr. Carnahan about his presence today?
There's a restraining order. We don't contact.
Okay, all right. Okay, so we were here I think we were here on the 7th of August. He was present.
Yes.
And he acknowledged on the 7th that he was served and received the pleadings for the hearing, but there was a lack of proof of service, which came in after the hearing.
He received the 4-page immediate ex parte, but he didn't receive anything else.
Right.
At the hearing on the 7th, but on the 14th, we had the sheriff serve him. which I believe there should be a return of service.
There is, yeah, it looks like he was served on the 14th of August, and it was noted up for a motion for today. Well, from the last time we were here, we just set it over to.
Yeah, I don't know if he got served with the last time we were here, but you said there was no need for service since he was here.
Well, he was served on the 14th with a summons and petition for a parenting plan, proposed parenting plan, financial declaration, immediate ex parte restraining order, a motion to appoint a guardian ad litem, the sealed confidential report. So it looks like you got all those documents on the 14th. So this is your motion for the restraining order, correct?
Yes.
Okay. There wasn't a filing from Mr. Carnahan in response to your pleadings when he was here. He acknowledged that he'd received the order itself, and we set it over to today, I think specifically for him to have provide some input if he wanted to.
That was my understanding.
Okay, okay. Okay, again, I'll call it the name Jack Carnahan if you're on the line. Jack Carnahan, if you're on the line, please unmute and state your name. Okay, so Ms. Vars, you supplied a proposed order, a restraining order. And it includes yourself and also Jessica,
Yes.
the minor child. Okay.
Yes. My main goal is just to keep her safe.
Okay. I'll go ahead and sign off on that order. Take just a moment.
When will I be able to receive a copy of that order?
Good question. Madam Clerk, can you give some guidance on when that order would be available for a copy or pickup?
You want anything else?
I mean, like, when will it be scanned into the Odyssey? Couple days?
It's about 2 to 3 days.
Okay,
Your other option is to wait until the docket's completed and the clerk could help you with a copy of it.
okay, I may just get it in a couple days. I'm late for a meeting, so.
Okay. All right, so I signed off on the restraining order.
Now, do I need to carry that on my person at all times, like I did the temporary restraining order in case he comes into contact with me or my daughter?
Some people take that extra precaution.
Okay, so it's not discouraged not to do that, okay.
No, I don't think it's discouraged at all. No, if there's a court order there, and if it allows police officers to more quickly ascertain the situation, that's helpful.
Okay.
Yeah,
Thank
okay,
you.
all right, thanks. Next, I have Katrina Vorse and Jack Carnahan, 24300158-08 is the cause number. Looks like Ms. Vorse is making her way up. I'll ask if Jack Carnahan is on the line. Jack Carnahan? All right, I'm not hearing a response from Mr. Carnahan. I'm just going to check the participant list, see if his name is listed therein. Jennifer, Julie. I don't see it. Mr. Carnahan, if you're here, if you'll please state good morning and state your name. All right, not hearing a response from Mr. Carnahan. Mr. Carnahan, you may be muted, and that's why I'm not hearing you. If that's the case, make sure you're unmuted and then state your name, please. Good morning to you, Ms. Vorse.
Good morning.
Ms. Vorse, you're here today for a motion for appointment of a guardian ad litem, correct?
Yes.
Okay. And it sounds like Ms. Day had previously worked on the case.
Yeah, she was involved since Jessica was taken in guardianship court.
Okay.
And so that's why I asked her to be,
Appointed.
yes.
And I'm here, Your Honor. Questions?
Welcome, Ms. Day. All right. So I don't have any issues with that. I think there's general continuity that's achieved when we have a guardian ad litem that's worked on the case before, and it's more efficient, I think. Let me double check with Ms. Day. Do you have any concerns if you're to be appointed to this matter as a guardian ad litem? It's a county pay case.
No, Your Honor, I think that's appropriate given my history so recently with the parties and the child, that there's a familiarity there with everybody involved. And I think that's appropriate.
Okay. All right. Very good. And just double checking, Ms. Vorse, you on your motion, the items that you're wanting the guardian ad litem to chime in on or investigate, or with whom the child should live, the parenting plan,
The whole shebang.
SUD, issues, mental health issues.
Everything, yeah.
Okay. All right.
I just want what's best for my daughter.
Right. Right. Okay. So let me just check off a couple of things here. Okay, I'm fine with the proposal. Let me just touch base with Ms. Day as far as dates and the like. So we're looking at a time frame of at least 60 days before trial. There's no trial date set currently in the case.
That's correct.
So generally, let's take a look as far as, do you have any proposed dates that you think, just with your familiarity with the case, Ms. Day, that you think you'd be able to have a report completed?
I should be able to have it by the early part of October, so 30 to 45 days to write the report and then set court thereafter.
Okay, so 45, so looking at. What about November 6th for a review of the guardian ad litem report?
That's perfect.
Okay, Ms. Vorse, are you okay with that?
Yeah, is that Wednesday?
It is.
Gotcha.
Okay, so we'll put the report due date for November 6th, then it'll be on the 9 a.m. docket. That's a Wednesday. And I will go ahead and sign off on that proposed order.
Am I required to serve Mr. Carnahan with anything further?
Related to this guardian ad litem appointment?
Yes.
Let me just double check. It would be helpful in that if Mr. Carnahan was given a copy of this document, then it tells him what he needs to do. It says all parties must serve the guardian ad litem with notice of any court proceedings or proposed agreement, copies of any documents that they file in the case.
Okay, I can have him served sometime within the next month and a half, so.
Okay, all right. All right. Okay, any other questions? Okay, Ms. Day, any questions on your end?
No, Your Honor.
Okay, I've signed off on that order. Thanks.
All right, thank you.
Thank you.
They had the GAL review on November 4th, which was after they returned to in-person hearings, so we don't get to see. But there was only one more hearing in the case, where I have to assume that Dad continued to be a no-show because the commissioner granted Mom's motion as a default. You can see that Mom got the restraining order that she asked for, as well as a final parenting plan. I'm not sure if Dad has any kind of custody at the moment, as he seems to have stopped showing up at the hearings, and according to Mom, is hanging out at a drug house again. That is sad news, but it seems like Mom is doing okay with the support of her family. I hope things go well for them. Thank you for watching.